Open the roll.
Mr. Chair, you have a quorum.
All right. First bill we're going to take up is Senate Bill 761, Senator Newman's bill, which I think is not quite ready for prime time, and I think that is a bill that would be appropriate for a motion to take by for the year. Is there a motion? It's been moved and seconded that 761 go by for the year. All in favor signify by saying aye. All opposed. That bill goes by for the year. Kristen, we're going to take up the conveyance bills next before we move on to patrons who are in the room. What's first?
353, Senator McClellan's bill.
353?
Yes, sir.
All right, Senator McClellan.
Good morning.
And Kristen, everything in order for this bill?
There's an amendment.
One line amendment to be made, Mr. Chairman, on line 32 after Virginia insert or his designee.
All right. Senator Stewart moves, Senator Norman seconds that line amendment. All in favor signify by saying aye. Aye. All opposed? And Kristen, would you mind telling us, just reminding us what the process is for reviewing these conveyance bills so that maybe we can move through these expeditiously?
Yes, Mr. Chairman, typically at the chairman's request, we have sent the conveyance bills to the AG's office to make sure that they're in good form, and the AG would be able to make the conveyance based on the information that is in the bill. And they have signed off on Senator McClellan's bill.
All right. Senator McClellan, anything extraordinary about your bill?
No.
All right.
Mr. Chairman, I would note that the Finance Committee did ask to review this bill.
All right. Senator Stewart moves to report and re-refer 353 to the Committee on Finance. Is there a second? Second. It's been moved and seconded. Clerk will open the roll.
Ayes 12, noes 1.
Thank you.
He doesn't want to see it in finance. Don't take it personally. All right. Next conveyance bill.
Senate Bill 587, Senator Stewart's bill.
Senator who? No. Kristen, everything in order here?
Yes, sir.
All right. Anything extraordinary about your bill, Senator Stewart?
There
Is
is
it ready to go?
There is not, Mr. Chairman. It's ready to go.
Anybody have any questions? Anybody in the audience wish to speak to this? Is there a motion?
Move to report and re-refer to Senate Finance.
I don't know. Does this need
Move
to
to
go to
report.
finance?
No, sir.
Move to report. Second.
All right. It's been moved and seconded that Senate Bill 587 be reported. Clerk, open the roll.
Ayes 13, no 0.
All right. That bill is reported. Next.
Senate Bill 888, Senator McDougall's bill. There is a substitute, but it really only changes technical meets and bounds. If you want to see it, I'm happy to share it with you.
Is there a motion to adopt the substitute? So moved. It's been moved and seconded. The substitute is before us. Anybody in the audience wish to speak to that bill? Anybody on the committee have any questions? Is there a motion on that bill? All right, it's been moved that Senate Bill 888 be reported. Clerk will open the roll. All
Ayes
right.
13, no 0.
All right, is that all? At least that we can handle expeditiously?
Yes, sir.
All right, that has a little hair on it. So we're going to wait for Senator Vogel to arrive. All right, Senator Chase, I'm sorry, you've got some people who are waiting, or you're waiting for. All right, Senator Black. We've got Senate Bill 270.
Yes, Senate Bill 270 was submitted at the request of the Loudoun County
Senator
Board of
Black,
Supervisors.
is Loudoun County here?
I have not seen
And let me
representative here.
let me just tee this up. I mean, basically, my understanding is that this bill says that if a school board gets a piece of property and there's an unrecorded encumbrance, they're not bound by it. My understanding is you ain't bound by it anyway.
Well, we have had some problems with it, and I do have a representative here if he could speak.
Apologize, Mr. Chairman, I was out in the hall on a conference call. We actually had a circuit court case in Loudoun County that said otherwise, and that's the reason for the bill.
Mr. Chair, I suggest we write a strong letter to that judge and,
Has
The
that
court
been
ruled.
appealed?
No, sir, this goes
Is
back.
it still
a few years.
pending?
No, it's been settled. It goes back about, I've got the case here.
2011.
2011, it's a 2011 case. And the county, the subdivision was developed and all the advertisements and everything.
Here's my concern.
Okay.
So we adopt this bill and say that for school boards, you're not bound by an unrecorded encumbrance that you're not aware of. I mean, the reverse implication is that maybe other people are.
I hear you.
Okay. And I'm sorry to put a fine point on it,
No,
but.
no, it's fair.
All right. Anybody have any other questions of the patron or Ron?
But you understand the issue.
I
You
understand
really
it
do.
very well.
Yeah, but, yeah, thank you.
Anybody in the audience wish to speak to this bill? Is there a motion? You want to pass it by indefinitely? Is there a second? All right, clerk will open the roll. I'm sorry, Dick, but,
No, I understand.
All right.
I understand the point that you make.
all right.
Thank you.
Next,
14,
we've
no zero.
got Senator Eben. So can you all call Senator Eben? Are you ready? I'm sorry, you ready, Amanda? All right, Senator Chase, 912.
Thank you, Mr. Chairman, members of the committee. I'll be presenting Senate Bill 912 relating to retired law enforcement officers and their ability to carry a concealed handgun when they return to work. Senate Bill 912 clarifies that a retired law enforcement officer shall surrender his proof of consultation to carry a concealed handgun when he returns to work as a law enforcement officer. The current law does not specify that his return to work be as a law enforcement officer. So just breaking it down here, when an
gotcha.
officer retires,
So the problem is that they have to return it.
Correct.
Even if they go back to work in a non-law enforcement capacity, which means that they may not have the ability to carry.
that's correct.
All right, that really does clarify. So anyway, does anybody have any questions of the patron? You have somebody
I
who
do.
braved the traffic to get here.
Yes, this is Kevin Carroll, who's the president of the Fraternal Order of Police of Virginia.
I thought you had a really impressive witness.
I do.
No, it's great to see you, Kevin.
Good morning, Mr. Chair, members of
We're
the
old
committee.
friends.
Yes, we are. Can't take a little ribbon, what the heck, right?
That's right.
So, yes, exactly what you said, Mr. Chairman, that, and I'll give you an example. We have a law enforcement officer that retired from Chesterfield County who came back to work in our property room. And he would, based on the way the law is written right now, he would have had to turn in his credentials, even though he came back working part-time as a non-law enforcement.
All right. Anybody have any questions of the patron or the witness? Anybody in the audience wish to speak to this bill? Is there a motion? All right. Is there a second?
Second.
It's been moved and seconded this fine bill be reported. Clerk will open the roll. All right. This bill is reported. Next, we've got somebody called Senator Eben. Huh? Okay. Senator Dance.
Good morning, Mr. Chair. Understand my
461.
461.
What?
My good bill that was coming from the Joint Healthcare Commission. You ready?
All right. 461.
Thank you, Mr. Chairman. Before we get started on my bill that's before you, I have a line amendment
Okay,
on,
does council have that?
no,
Okay.
I've just got.
You just wrote it?
The trial lawyers have reviewed it, and they had a friendly line amendment that we'd like to have added. It's on line 30, after the word "the," insert information was true and.
I'm sorry, where on line 30?
Oh, you don't have the substitute? I'm sorry. You don't have the substitute in front of you?
Mr. Chairman, there was a substitute adopted in House, or in Senate Ed and Health that should be on LIS for everybody's review.
Okay. So on line 30 of the substitute, provided that the,
Line 30, insert the word THE. After the word THE, insert information was true and and it picks back up the employer was not acting in bad faith.
all right, does anybody move that amendment? It's been moved and seconded. All in favor signify by saying aye. All opposed? Okay, that amendment is adopted. So, Senator Dance, my understanding is that this bill essentially gives immunity for information provided by a school employer to another school employer about an employee, right?
I guess to give you the direct preference, it says it will allow anyone that's providing, we're dealing with
A direct
clients with
service
Medicaid
provider.
waivers, so any service provider that is providing the care and they employ
Yeah, you're right.
one, you want to make sure that the people that they employ have
Yeah,
not
not-
had a previous record of doing bad things to people, because these are some of our they're intellectually disabled, and have the highest rate of abuse, neglect, and
Well,
exploitation.
And my question to you, and I'm sorry, I'm confusing this with another bill.
Okay.
I understand that. But my question to you is, I mean, and you may not be able to answer this, and maybe a question for counsel, but my understanding is that that immunity already exists.
Exactly, and you would say, why do we have it here? Because we want to make sure the providers, it's clearly defined for the providers that we're gonna be using this, that they are protected. And so sometimes, like me, they're not lawyers, and so this is clearly defined, if that makes sense to you, sir.
Well, I mean, it does, but we've got a lot of different provisions in the code dealing with a lot of different professions.
Okay.
And
Can I let her speak and explain?
well, hang on just a
Okay.
second, but if we put this in for direct service providers just because they want to make sure that it applies to them, I mean, aren't we going to be putting it in code for, every profession that's defined?
We're only dealing with direct care providers that are providing services to clients who are intellectually disabled and most vulnerable, and to make sure that they are protected.
Mr. Chairman.
This is upwards.
Senator Norman.
Senator Dance, can you define for me the universe of direct service providers that this bill would impact?
The universe of direct care providers?
Who would this encompass?
Okay. If I'll give an example. If I was, my child had been discharged, a training center had closed because I had no choice, and my child is.
I'm not interested in the factual situation. I'm interested in what are the group of direct service providers that we're going to encompass it. You seem to be focused on a more narrow situation. I'm concerned about what the universal definition of the people who this bill would impact.
I will let her give us the universe.
Good morning. My name is Paul Margolis. I'm with the Joint Commission on Healthcare. The providers that are subject to this proposed legislation would be people that provide personal care, pre-vocational training, that help with activities of daily living, feeding, dressing, bathing, individuals who provide services through the 3 home and community case services waivers that serve people with intellectual and developmental disabilities.
Mr. Chair.
Senator Lucas.
Sorry, thank you, Mr. Chairman. For direct care providers, there is a CRIS system, the Comprehensive Human Resources Integrated System. Anytime an individual who's working for a direct care provider is found to be in violation of those regulations, they automatically go into the CRIS system for all other providers that have that information. So if you've have a founded case of abuse, neglect, after having worked for a private provider, that information goes in the CRIS system, and everybody in the universe has it.
If I may, it is true if a founded case, they do go into the CRIS system, but there is also the Adult Protective Services and Child Protective Services, and there was concern expressed that there may be cases of individuals who do abuse or exploit individuals who go under the radar. They may see the writing on the wall, they leave their employer, they go to another employer, and this would provide an opportunity for the potential employer to get a honest reference from the previous employer without fear of being persecuted for providing accurate, truthful information.
Senator Lucas.
Yes, sir, Mr. Chairman. I don't intend to do any harm to Senator Dance's bill, but once the individual is entered into the CRIS system, all of the details of the abuse, neglect, or whatever the violation was, goes into that system for any other provider in the universe to have access to it.
Okay. Anybody have any other questions of the patron?
Mr. Chair.
Senator Peterson.
As I understand, the purpose of this bill is basically to say you cannot disclose information about a provider unless you have their written consent.
No, sir, there is language that does specify that consent is not required.
Well, then why do we have the bill?
Well, it would be, if the potential employer asks for consent and the candidate denies it, then that may show a red flag, or there may want to be more questions about why they don't want their previous.
Well, why do you need to have that in the code? I mean, that could show a red flag anyway.
Yeah.
Yes, sir, but it would just provide, it's again providing the protections for the previous employer to be able to communicate honestly and accurately to the potential employer.
Senator Stewart.
Mr. Chairman, Senator Dance, I think this is an admirable goal that you're working on, but I think the coverage already exists. And to Senator Lucas's point, this could create some difficulties as a result of this bill. So I know you want to try to accomplish something. I would suggest that maybe.
This came as a concern. We didn't just go out and say,
Right, I'm
let's do
suggesting
this.
maybe that
Go
we
ahead.
could work on this over the course of the year and get this bill right, because I'm not sure, based on what I've heard, that it is right. So with that, perhaps the right thing to do would be to carry this bill over for the year.
Okay.
That's a motion.
All right. Motion's been made and properly seconded. Clerk will open the roll. To pass the bill by. Yeah.
Ayes 14, noes 1.
Thank you.
Thank you, Senator Dance. All right, next we've got Senator Eben. And I think we've got maybe three bills that cover the same subject matter. We've got Senate Bill 3, which deals with the marriage provisions of the code. Senate Bill 603, which does that and replaces gender terms throughout the code, which is the broader version of Senate Bill 3. And then we have Senator Edwards' bill,
SB 50.
SB 50, which is identical to your SB 3. Is that right?
That's right.
So we're going to take up Senate Bill 3 and 50, and I don't know what y'all's preference is for how we deal with these. And then we'll take up 603. So we'll take up the narrow first and the broad second. So if 3 and 50 report, then we can move on. If they don't, then 603 probably won't either. Kristen, they identical? Yeah. Okay. Well, let's take that up at the end. Let's let Senator Eben make his presentation. Anything Senator Edwards wants to add would be fine. All right.
Okay. Senate Bill 3 brings Virginia Code into alignment with Ogerfell versus Hodges, which is the Supreme Court decision that repeals the now defunct bans on same-sex marriage and civil unions. And this was, as Senator Edwards said, the unanimous recommendation of the Code Commission. And obviously the ban is no longer valid throughout the U.S. And the Code of Virginia, I believe, and I think the Code Commission certainly believes, needs to accurately reflect the law, removing any legal ambiguity. That's the bill. We repealed our anti-miscegenation law in 1968, just 1 year after Loving versus Virginia. We're now approaching 4 years after the other decision, and I would just ask that you concur with the Code Commission.
All right. Senator Edwards, go right ahead. Can you turn? John, I can't hear you.
The Code Commission did unanimously support Senate Bill 50 on the grounds that the current law is obsolete based on the Supreme Court's decision. And it was a unanimous decision by the Code, and it's identical to Senator Evans' bill.
And I might add further, this was also sent to the Attorney General's office at the suggestion of Delegate Habib, the Vice Chair of the Code Commission.
He's not Vice Chair, but
okay.
the Attorney General has an opinion saying that it's obsolete. And the Code Commission deals with obsolete bills on a routine basis.
Okay. Anybody have any questions of the patron? Anybody in the audience wish to address this bill?
Good morning, Chairman, members of the committee. James Parrish with Equality Virginia. We appreciate Senators Edward and Eben for introducing this bill. We agree with them and the Code Commission that we need to have a clean code in Virginia. Marriage between same-sex partners is legal in this state and all 50 states, and our code should reflect that. Thank you.
All right.
Mr. Chairman, members of the committee, Claire Guthrie Gaston-Yaga, on behalf of the ACLU of Virginia, we'd like to associate our comments with Mr. Parrish and the Code Commission, and we strongly urge you to pass this bill.
Thank you. Anybody else wish to speak in favor? Right, in opposition.
Good morning, Mr. Chairman, members of the committee. My name is Josh Hetzler on behalf of the Family Foundation. The bill before you would have you repeal natural marriage as between a man and a woman from the Code of Virginia. In doing so, you would discard 400 years of this recognized institution in the Commonwealth. Removing the definition of marriage in Virginia would not only be hasty and reactionary, it would be wrong. It is said, it has been said that the U.S. Supreme Court has spoken on the issue of marriage, and indeed it has. Less than 3 years ago, the court voted 5-4 to redefine the institution as old as time itself, cloaking it with the veil of constitutional legitimacy. Yet, as the Chief Justice aptly pointed out in that case, the Constitution had nothing to do with it. He knew then what we know, that we still know today, that it was a decree of the will and not a restatement of law. As state legislators, you may choose to bow to the gross federal and judicial overreach of the court's opinion on marriage, then so be it. But we understand the predicament it poses for you. Nevertheless, one thing remains certain. A vote to repeal Virginia's marriage statutes will change absolutely nothing. Its only practical effect at this point would be a symbolic one. It would represent this legislative body's official imprimatur on the idea that marriage really is something other than a man and a woman, that marriage can also be a man and a man, a woman and a woman, or whatever other combinations the court decides to create next. So not only is a vote to repeal marriage in Virginia totally unnecessary as a practical matter, but it would be a bold statement by every legislator who votes for its repeal that he or she stands in contravention to the millions of Virginians who continue to recognize marriage as between a man and a woman, and who voted decisively in 2006 to memorialize this definition in Virginia's Constitution. And while the General Assembly of Virginia cannot control what 5 members of the United States Supreme Court declare by judicial decree, the members of this body unquestionably do control what it asserts through the statutes of this Commonwealth. So then it is no longer a matter of what the Supreme Court has done or what it thinks about the institution of marriage. This is about what you will do in your representative capacities with regards to the laws on marriage in our state laws. And for still millions of Virginians, this is a clear line in the sand that ought not be crossed, and they are watching. In conclusion, we urge you to reject what amounts to a purely symbolic action and to retain the truth about marriage in the laws of this Commonwealth. The truth that marriage, by its very nature, is and always will be between a man and a woman. Thank you.
Mr. Chairman.
Senator McDougal.
Before you leave, can you answer a question for me? I didn't get your name.
Josh Hetzer with the Family Foundation.
Your thought is, if I listen to your argument, you think that because the people have spoken, we should not do this because the people voted on a constitutional amendment. Is that accurate?
My point, Mr. Chairman, Senator McDougal, is that there are many, many Virginians whose view reflects the one that is currently written into Virginia's law, and that it ought to remain that way, notwithstanding what the Supreme Court has decided and what this body may acquiesce to as a matter of policy, but as a matter of laws on the books, we think it ought to reflect the truth about marriage as between a man and a woman.
Mr. Chairman.
Senator McDougal.
So based on that, you think that if it should reflect the views of Virginians, then that's an advocacy for us putting a constitutional amendment back on the ballot for Virginians to make that determination?
That's a question that you could take up next year, certainly. But it's
So you would be in favor of that, letting Virginians decide?
We'll cross that bridge when we get there.
We might help you with the planks.
All right.
We just
Time
stand
is
with
up.
that. I know, we just stand with comments that were made, Virginia Assembly Independent Baptist.
All right, thank you.
Mr. Chairman, members of the committee, thank you. Bill Ray with the Virginia Catholic Conference. We also oppose this bill.
All right, thank you. All right, anybody have any questions of the patron? All right, the bill is before us.
Mr. Chairman, I just have a brief statement. Thank you, Mr. Chairman. I've been in a very happy marriage for over 51 years. I doubt anybody else up here has been so fortunate yet. And it has been loving and caring and deep relationship. And I don't see why anyone would deprive anyone else of that joy and that relationship. I really hope everyone will vote for this.
All right, bill is before us.
Mr. Chairman?
I'm sorry, Senator Eben.
Very, very briefly. I think that when we talk about what the people of Virginia think, I think that the train has left the station and polling is different if it was on the ballot. But further, we've had same-gender marriage and the sky has not fallen. And there is a difference also between marriage and holy matrimony. This bill in no way encourages or not encourages, in no way prohibits any church from limiting marriage as they've done before. So what we're really talking about is legal marriage with people getting the responsibilities and privileges from the state as they have now.
All right. There's motion to report.
Substitute motion.
Well, there's no second yet. I'm sure there will be.
Move to report.
Okay. All right, Senator McDougal.
Substitute motion is to give the opportunity for the constitutional amendment to come forward next year that we carried over for the year.
A second, move the pending question.
All right. The
I'll move the previous question.
Well, hang on. Hold on. Time out, just a second. The motion that was made was, the primary motion was to roll these two bills together, I assume, and to report them together as Senate Bill 50, or excuse me, as Senate Bill 3, with Senate Bill 50 rolled in and Senator Edwards named as a chief co-patron. That motion, that was your motion?
Yes, yes.
Okay, I thought that's what I heard. And the substitute motion was to carry the bill over for the year. The pending question was moved. My understanding is we vote on the pending question.
The previous question.
No, the pending question was moved.
I moved the pending question, and there is no debate on it.
That
There
is,
no substitute.
that is what is.
I moved the previous question before
that. That is what is before us, is the pending question, which is to carry the bill over for the year with, as Senator McDougal said, with the idea that next year the voters may be given an opportunity to act. So the pending question is to carry the bill over. Clerk will open the roll.
Ayes 8, no 7.
All right.
Okay. I assume you don't want me to present the second bill?
No, I mean.
Okay. I have a statement real briefly.
I mean, certainly we're going to take it up. I mean, we take up every bill.
Okay.
And so your second bill is Senate Bill 603, which is the broader bill.
It is, and this bill deals with a lot of other obsolete provisions, but
Right.
it's, the Code Commission, or the subcommittees of the Code Commission held that these were uncontroversial as they go. And I did want to point out that there's some back and forth. This committee voted to send the other bill and this 603 to the Code Commission before, and the Code Commission had a broad discussion about what its responsibilities were about obsolete laws, and even sent it to the Attorney General. And both members of this committee that are on the Code Commission did vote differently on the other bill. Now, this bill repeals specific prohibitions to marriage that are no longer valid, and there were lots of subcommittees that included groups like the Equality Virginia, the Family Foundation, the Catholic Conference, et cetera. Now, these ones are ones that no one voiced an objection to in a larger, long chain of emails that went around for some time. And the Code Commission had this for a few years. But most of the experts, I should say, in the committees were people like the Bar Association, Attorney General's Office. I can read the names of the Attorneys, Health Plans Association, that sort of thing, realtors. And basically, right now, same-gender couples are allowed to adopt, make medical decisions, inherit property. And these were ones that, again, that there was no objection to. They deal with taxation, property rights, marital rights, divorce, birth records, birth certificates, and other fields. This is what's already happening in Virginia. And again, Loving versus Virginia was changed in less than a year. And I believe that attorneys, judges, court clerks, accountants, realtors, law students, and the public all deserve to be able to consult the code for an accurate representation of Virginia law. Even me, a legislator who's not a lawyer, deserves to be able to look at the code and understand it easily. There are about 18 code sections affected here in this 35-page bill of the 80 that were originally brought up. They include things like property rights, marital rights, divorce, birth records, birth certificates, marriage records, having an insurable interest in the spouse, inheritance rights, workers' compensation rights, spousal immunity, duty to support, requirement that the spouse joint wage assessment or lien, rights to surviving spouse, and right to hold property with right to survivorship. They merely changed words to words like spouse, spouses, spousal, married individuals, privileges of marriage, parents, other parent, either parent or decedent. And while I know it's not why we make decisions here, there was a front page article of USA Today last week that talked about Amazon relocating their second headquarters, and it talked about the effort by some to have Amazon locate in a state that's not moving backwards. And it takes a while to do a constitutional amendment, which might be an argument against this one as well. But this is really, I thought, simple. And I'll just tell you where there was an agreement. There was an agreement on things like assisted conception, adoption, some punting on a few other pieces, home birthing, surrogacy. That part was not changed by this bill. This is basically taking that 88-page bill that you've referred to the Code Commission, the broader concept, and agreeing with the Code Commission, with the subcommittees of the Code Commission on the uncontroversial portions. This does not eliminate, or I should say, it just changes the words in the Code Commission largely. Now, it does take out the ban as well, which you could all leave in if that's your will. I don't know why. But to get this on the ballot, I don't know if you're all going to vote to put this on the ballot next year. I can't, predict that. But if that's the reason for not going forward with this bill as any other, then I've got to assume that you want it on the ballot where polls show that sort of thing will pass. But even if it's on the ballot, that does not change the words in the code. It just changes the Constitution. This would merely bring us closer to alignment with the law of the land and show that Virginia has some forward thinking or gets caught up a bit, much as we did in Loving versus Virginia in less than 12 months. This would be less than 5 years.
Yeah, Mr. Chairman,
Senator Edwards.
as chair of the Code Commission, we do have in the Code Commission a subcommittee looking into this very issue, which is a lot more complicated than most people realize. But what this bill does is take out the uncontroverted issues and put it, as I understand it, changes, for example, things like instead of husband and wife, the words would be spouses, or instead of that type of thing. Very controversial changes in wording to conform to a gender-neutral code. That's basically what it does, and that's my understanding. Is that correct?
Yes, sir.
Okay.
All right. Any other questions to the patron? Anybody in the audience wish to speak in favor of or in opposition? Step right up.
Chairman, members of the committee, James Parrish, Quality, Virginia, and we support this bill. Thank you.
Thank you.
Mr. Chairman, members of the committee, Claire Guthrie Gastineaga, on behalf of the ACLU of Virginia, we also support this bill.
All right, thank you. Anybody else in favor? All right, step right up.
Mr. Chairman, Josh Hetzler with the Family Foundation. Just say many of the terms and changes in Senator Evans' bill here are rather innocuous in and of themselves. But then again, we do have a rule of statutory construction that's actually in the code that addresses gender terms that basically it says that if it's one way, it should be assumed and read to be also, if it's male, it also means female.
All right.
And so this is a rather unnecessary item as I referenced earlier. And we ultimately believe that male and female do matter, words matter. And there is no reason to change the code in this way.
Thank you.
Thanks.
Yes, sir.
Mr. Chairman, members of the committee, Bill Ray with the Virginia Catholic Conference. We also oppose this for the reasons stated here. Thank you.
Thank you. Yes, sir.
Really briefly, I would point out that the Family Foundation was on the Banking, Wills, Trusts, and Estates Real Property Subcommittee. The Family Foundation and Catholic Conference were on the Domestic Relations Subcommittee. The Family Foundation was on the Criminal Law Subcommittee. Family Foundation, Catholic Conference were on the Health Insurance Healthcare Subcommittee. The subcommittees were open to all, although they were mostly represented or almost exclusively by attorneys. They were also on the Housing and Employment, Housing Committee Subcommittee, Employment Subcommittee. This is just fixing some words in the code to represent the current state of law. I would also point out, although I guess it was just on the last bill, everyone on the Code Commission, whether it was Delegate Habib, Senator McDougal, former Delegate Lemunyan, sitting judges, and others voted for the last bill. I can't speak to this bill because it was subcommittees, but there was a long chain of emails, and the original bill would have been this thick. I've taken the favor for you of skimming it down, trimming it down to 35 pages that I've highlighted here if anyone would like to look at it.
Okay. All right, bill is before us.
Second.
It's been moved and seconded that the bill be reported.
Substitute motion, Mr. Chairman, I move it be carried over for the year
All right.
and move the pending question.
All right. Substitute motion is to carry the bill over for the year. The pending question is that clerk will open the roll.
Ayes 8, no 7.
Thank you.
Thank you. Senator, I'm sorry. And vote on what we will. Yeah. All right. In a minute, we're going to have to divert from the sign-up list because we've got some members of this committee on a Commerce and Labor subcommittee. But for right now, I guess we'll go to Senator Wexton, Senate Bill 426.
Thank you, Mr. Chairman. I'll do my best to get through this quickly. I have Senate Bill
Substitute.
426. There is a substitute.
Senator Edwards moves. Senator Peterson seconds the adoption of the substitute. All in favor signify by saying aye. All opposed. The substitute's before us.
And do not let the length of the substitute scare you. The reason it's so long is because this provision is appearing in every part of the code in which we have protective orders, whether they be EPO, PPO, or permanent protective orders. And what the substitute does that changes it from the original is that it calls for this list of resources to be compiled annually and reviewed for accuracy by the Advisory Committee on Sexual and Domestic Violence. That group has indicated that they would be able to compile that information and review it annually for accuracy, and that they are better suited to compile that list of information than the courts. The courts would be able to then distribute it. The courts or magistrate, as the case may be, would be able to distribute it.
Okay. There are a couple of questions. I'm going to ask you these kind of in bulk. Okay. Well, let me just first ask, Supreme Court have a position on this?
We have no position on the substitute.
Okay. No position on the substitute? Why? What's changed that?
Our only concern on this bill was who would be preparing these lists of resources.
Okay, and your substitute changed this how? Who's preparing it now?
The substitute provides that the Advisory Committee on Sexual and Domestic Violence would compile the list and review it annually for accuracy, and then it would be distributed.
Who is that, a governmental body?
It is a committee that, yes, it is. We can defer to the clerk about exactly who is.
That's our council.
Council, I'm sorry, to council about exactly who is on that commission.
Charles?
Mr. Chairman, it is a government entity.
Mr. Chairman.
Senator Stewart.
Just so I understand, who are they affiliated with? Who do they serve under? Who appoints them? As much as you know.
And how many members are there? Do you know?
I don't know how many members there are.
And I'm sorry to interrupt. I mean, I know we just asked you this question, but this is for 123 localities. And I mean, Senator Norman and I are sitting here talking about our different practices in our localities, and I think that his jurisdiction actually prepares a little booklet I don't know whether mine does or not. And so the commission would be charged with coming up with a complete list for each of the 123 jurisdictions.
Well, Mr. Chairman, the way that I would envision this happening is they're making a decision about the best way to do that. And in some places, it may be a circuit-wide list. In others, it may be better to do it on a locality-by-locality basis.
Sir Norman.
I apologize for my ignorance, which covers a lot of subjects, but I'm really not familiar with this advisory committee. And going back to Senator Stewart's question, I mean, how large is this committee? How active is it engaged? Because you're talking about 123 different jurisdictions that have a wide variance of resources that may be available. I'm interested in what she says.
Mr. Chairman, Senator Norman, I know that there are I believe there are legislative and non-legislative members on that committee. Senator Favola is currently the chair of the committee, and there is staff that helps to staff that committee as well. Do you have any more information? Mr. Chairman,
right.
Council has pulled up the section for that, so if I think he would have additional information if that would.
Mr. Chairman, the Advisory Committee on Sexual and Domestic Violence is provided in 9.1, 116.2. It consists of 15 members or their designees, the Commissioner of Social Services, the Director of the Department of Criminal Justice Services, the Commission of Health, the Director of the Department of Housing and Community Development, the Executive Director of the Virginia Sexual and Domestic Violence Coalition, one member of the Senate to be appointed by the Senate Committee on Rules, one member of the House of Delegates to be appointed by the Speaker, the Chairman of the Virginia State Crime Commission, and the Attorney General. There shall also be 6 non-legislative citizen members appointed by the Governor. So it's 15 people. It does sit as the code does provide it as an executive branch of state government.
So your understanding, though, is that many courts do this already?
Mr. Chairman, some courts do and some courts don't. There's really no consistency. And one of the things that we learned from some of the bills that were before the Senate and the House last year is that there are efforts afoot to provide more resources to victims of domestic violence. And this would be an opportunity to do so.
All right. Have you talked to the Office of the Executive Secretary about what they can do to make sure that there are uniform practices among courts across the Commonwealth?
Mr. Chairman, their concern had really been about making sure that whatever information that they're going to be providing is accurate information. Providing the information did not seem to be an issue for them. They did not seem to have a problem with the logistics or the opportunity to provide the information, just whether it would be accurate and that it was not really a part of their mission to compile that information.
Mr. Chairman?
And that's what the substitute seeks to deal with.
2 questions, and I assume this language that I see on 100 through 106 is repeated in each different section. Is that accurate, Charles?
Mr. Chairman, for the most part, that is accurate. The language will change depending upon if it's a preliminary protective order or emergency protective order. Or
Mr. Chairman, further question?
Senator McDougall.
If I'm reading this correctly, Charles, it says the court shall provide the petitioner. It's not another group, it's the court. Is that accurate?
It's either the court or a magistrate if the magistrate has the ability to issue that protective order.
Mr. Chairman?
Senator McDougall.
So if the court does not or the magistrate does not, is there some sort of liability that's placed on them for not?
There is no penalty or liability provided for in the code.
Mr. Chairman?
Senator McDougall.
And does it, anywhere in the bill, does it say who's paying for all these copies that are going to be provided?
No, it does not, Mr. Chairman.
Senator Stewart.
Mr. Chairman, kind of following up on Senator McDougall, if I read this bill correctly, you have a commission in the state that will be looking into and fleshing out resources in each local jurisdiction, and then they have to compile a list for each local jurisdiction to be distributed by the court. Is that correct?
That's correct. And local jurisdiction would depend upon, how they determine those resources would be available for the various locations.
Exactly, Mr. Chairman. And that seems to me to be a pretty insurmountable task for this committee, because they have got to determine what resources are available potentially in every county or in every subdivision of a county, and then review that annually to make sure it's accurate and make sure that it is distributed by the court. I just don't see how we task a state-run commission or committee to do that. I like what you're trying to do, and I think it's a really good idea. And in almost every court I practice in, they already do this, but the locality does it, and they provide a list of those resources to the person that would need it. But it just seems to me to be a good goal, but an insurmountable task for this particular committee to do it. I think it would be wise if we carried this bill over for the year.
Mr. Chairman,
and worked on it.
Senator Stewart, that is kind of the purpose of this committee, is to at the state level, determine what those resources are and how they should be allocated. So
right.
I
So-
would say
Mr.
there are some people who are
Hang
here
on.
to speak in favor of the legislation.
If we can, why don't we do this? Why don't we hear from people who want to speak in favor of it? And those who, if anybody wants to speak in opposition, and then figure out what we're going to do. Those who wish to speak in favor, step right up.
Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. So to speak to the question of who occupies those non-legislative seats on the Sexual and Domestic Violence Advisory Committee, it's Rape Crisis Center directors, Domestic Violence Center directors. This is actually already a task that the Action Alliance, a statewide coalition, oversees, that we already have access to. And so this would be making those resources more readily available to victims of domestic violence and sexual assault. Our data from the field from the past 6 years or so of collecting feedback evaluation from survivors of sexual and domestic violence who receive advocacy services is that they report consistently enhanced mental and physical well-being, reduced risk of experiencing abuse again, increased access to vital community services, including healthcare and housing, and strengthened social support networks. I have a number of quotes from survivors that I'd be happy to share. One of the things that we're trying to do is make this a consistent practice across the Commonwealth, and we believe we have the networks and the tools and the resources to make that happen.
All right, thank you very much. Anybody else? All right. Senator Howell, do you have something you want to say?
Yes, I did. I am struck that some people think this would be insurmountable. The sad fact is there are very limited resources available for people who are victims of domestic violence, and then they need to know what they are, where they are, and how they access them. To me, this is a great bill. It's building on work that we've been doing for 20 years here in the General Assembly to help protect victims of family violence. They are at huge risk when they get that protective order. That's probably the most dangerous point in their lives, and they need to know where they can go and how they can access help. I think this is a great bill, and I hope we're going to pass it.
Senator Norman.
Mr. Chairman, I actually have read the bill and the substitute, and I think some very salient points have been made, but I would like to be assured that if we were to pass this bill, that we would have the resources available to implement it so that those who would benefit from it would receive those services. So I would move to report it and refer it to the Committee on Finance.
There's a motion, properly seconded to report the bill and re-refer to Senate Finance. Any discussion on that? If not, clerk, please open the roll.
Ayes
Unanimous.
15-0.
Thank you, Mr. Chairman.
Thank you, Senator Wexton. Mr. Chairman, you're back. All right.
I'm back. All right. Let's, and I'm sorry for the patrons who are here. We just have a couple of folks on the committee. We just need to get someplace else. Senator Chafin, you got one bill? 774.
Good morning, Mr. Chairman, members of the committee. Yes, Senate Bill 774, it deals with partition suits, and this is a matter that I've seen come up time and time again when you have owners of businesses, for example, and they are financially capable of purchasing properties that the businesses may lease in the business, and maybe they get into some type of a dissolution suit or something of their corporation. Then they also have an argument about the property, the real estate property, and it becomes the subject of a partition. What this bill would do would allow the court to determine, if the court determined that the parties were financially able and interested in the property, that then the court could order a private sale between them as opposed to a public auction.
Ben, here are a couple of thoughts, and I'm currently in the middle of a dissolution case and am intimately familiar with the provisions. And there is actually a provision in our corporate code dealing with dissolutions that does exactly that. I mean, if one member of a corporation or one shareholder moves for dissolution, the other or another shareholder has the ability within 60 days to elect to purchase the shares of the movement, and the court has the responsibility of setting a fair value, and the factors are given there. So there typically is an appraisal, a business valuation that's done, and I guess, so you're not talking about a corporation, are you?
I'm not talking about a corporation. I'm familiar with the election. I've been involved in suits that dealt with the election, both when it was made and not made. I'm talking about where the land is owned by individuals. All right, and here's a hypothetical. You have a corporation owned by two individuals. They have a dispute. They have a dissolution. One of those individuals files for an election to purchase the other's shares in the company. The case goes through. But they also own real estate that they've leased in this company, and all of a sudden they have a partition suit and an accounting suit with regard to that real estate. And so one of the brothers or partners or whomever they are wants to push them out, and they want to say, guess what? We're going to sell this out from under you. We're going to have a public auction, even though that business may still be located on that real estate as a holdover tenant or as otherwise. So this would allow the court to determine those issues and the equity of those issues, and then order a private auction between them, so that the public would not participate. That's the thrust of this bill. And it could also be family members who own a family farm, and all of them want to buy. There's 5 of them, and they all want to buy, and somebody wants to push it to the public.
Senator Stewart.
Mr. Chairman, Senator Chafin, I guess my question would be, why would you want to do that? Wouldn't that drive the price of the asset way down if you limited the participants in the auction?
Well, I don't think so, Senator Stewart, Mr. Chairman. I would say I don't think so, because first the court would have to determine that all the parties, all the co-parceners want to buy. And then the court also has to determine that they're also financially capable of buying. So you would have people dealing with people at arm's length, and they would have a private auction, as opposed to ordering a public auction which would be damaging to whichever party might be in control of that property.
Mr. Chair,
Senator Deeds.
wouldn't you?
I'm sorry, hang on. Let Senator Stewart finish.
Well, the only thing I was going to say is the court is able to make that first determination now that as to whether or not the co-parsoner wants to buy it, and they can do that. But in the event that what's troubling me here is you're limiting the pool of people who could participate, and I understand why you might want to do it. It would benefit the person who wanted to buy, but it could be a great detriment to the owners of the asset of whom is being sold. That concerns me.
And Mr. Chairman, I would say to Senator Stewart that that person would have already also indicated they wanted to buy. So they would be setting the price. They would be setting the price. We've seen cases where people won't agree to buy or sell for a number. They simply won't agree to a number, and I'll offer to buy it or sell it at this, but the other party won't agree to that because they want to push it to a public auction to impugn the business or whatever activity is going on that property to damage it. And so what this would do would be let them sit down in a room and sit right there until they reached a price on it.
All right, Senator Deeds.
Senator Chafin, couldn't the only way you avoid the problem that Senator Stewart's addressing is if you required the parties to consent to the private auction?
I think if this were authorized by the General Assembly, I believe that this would be another mode for partition as prescribed by the law.
But Mr. Chair, what I'm saying is unless both parties or all the parties consent to the private auction, you're potentially setting up an auction that's going to be the detriment of one of the parties' interests, one or more of the parties' interests. So what your remedy could work if the parties consented to the auction, to the private auction.
Mr. Chairman, I would say to Senator Deeds that if the parties consented to a private auction, this wouldn't be necessary. Okay, so what I've seen in what I have seen out there in cases and also from county to county, because we do a lot of real estate work, and I've seen these cases where the parties simply want to grind an axe. They want to purchase the property. They have the ability to purchase the property. They're going to bid at the public auction.
Ben, wouldn't it be more fair, and I'm trying to come up with something that may address some of these concerns, wouldn't it be more fair if you had the same kind of election and delegation of the court of establishing a fair value as exists in corporate law? I mean, here, you've set up the scenario, I think, very well, and I understand you're talking about somebody who may be vindictive and wouldn't consent. But I'm concerned about Senator Stewart's issue of not getting the maximum value. I mean, that's you either partition in kind or by sale, and if you can't divide it down the middle, you partition by sale in order to make sure that both parties are fairly compensated. Just like if somebody files that partition action, why not set up an election for the non-petitioning owner and give the court the obligation to establish the fair value, just like we have in corporate law. And that way, you don't have the gaming problem that exists here, and you have a court delegated the responsibility of establishing a fair value, which basically is a battle of the experts. I mean, would you consider something like that?
Mr. Chairman, I would consider something like that. I think that what I'm getting at is under current law, everybody can say they want to purchase it, and it just forces it to a public auction. And the motivations for that are not always pure.
And that's exactly why in a dissolution case, I mean, it used to be that one shareholder could be a tyrant and file for dissolution. And the uniform commissioners, uniform code commissioners said, basically, it's not fair to the non-petitioning shareholder. And we ought to give them an outlet and say, you've got the ability to make an irrevocable election to buy, but you're stuck with whatever the court establishes as the value. I think that may be the way to address this.
Mr. Chairman, I think it would be a method, a mode that would promote an equitable result in a lot of cases. I do.
So, and I'm not, I mean, we're going to try and finish the docket today, but do you have enough interest in that to offer a substitute, maybe at the desk on Wednesday?
Yes, I do. I do.
So
I'll
suspect
try to put
that
something together.
May have some difficulty with the existing language.
Well, I mean, my goal would be to go and look back at the corporate dissolution statute and just see if I could find something that would allow another mode on parity with that.
I suspect it will lay over this really nicely. Is anybody in the audience, is there anybody in the audience who wants to speak in favor of or in opposition to this? All right, if not, anybody object to carrying this over for the day? All right, let's do that. All right, without objection, it's going to go by for the day.
Thank you.
Okay. Next, we've got Senator, and with apologies to Senator Serbell, Senator Stanley. If you're not ready, we can go to Senator McDougal.
Which one would you like to handle first? 779?
All right, Senator Stanley.
Code, it's not going to be.
Got Senate Bill 777.
777.
See how lucky it is.
Thank you, Mr. Chairman. Senate Bill 777 deals with an issue as
You want to move the
Oh, I have a substitute, by the way, yeah.
All right, Senator Stanley moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us.
Okay, Mr. Chairman, members of the committee, Senate Bill 777 creates a way to overturn wrongful convictions based on new or discredited forensic science evidence. You know, as you know, if you're a practicing attorney, there are very limited circumstances upon which someone can attack a conviction. Under Rule 1:1, of course, we have the 21-day rule, which makes all judgments final. Basically, that leaves two avenues in which to attack a conviction, and that is a writ of actual innocence and, of course, a habeas petition. In Virginia, we've had 11 wrongful convictions based on false or discredited forensic evidence. So usually under these 21-day rule, discrediting of forensic scientific evidence doesn't happen within 21 days. It usually happens over time. One example would be the bite mark evidence in the Norfolk case. I think it's the Norfolk 4, and that was discredited. And of course, in the end, cost the state millions of dollars in terms of what we then have to compensate those that have been wrongfully convicted. This provides an avenue for justice if new or discredited evidence casts serious doubts on that conviction. Court of Appeals under the statute would have the ability to accept a petition, a writ, and vacate the conviction if it finds four criteria are met by a preponderance of the evidence. First, that the petitioner did not commit the crime or engage in conduct that would be considered a lesser offense. Two, that there is specific forensic evidence that is relevant in demonstrating that the petitioner did not commit the crime. 3, that the relevant forensic scientific evidence was not available at the time of the conviction or discredits the forensic scientific evidence used to convict the petitioner. And 4, had the forensic evidence been presented at the time of the conviction, the petitioner would not have been so convicted. Inside of this bill, there are safeguards to minimize the impact on the court system. Petitions can be, as you will see, repeatedly summarily dismissed, and there is a sunset provision which sunsets this statute, this legislation in 5 years, so we'll be able to properly assess the impact and effectiveness. As you know, I think, especially as a criminal defense attorney, we do not have a perfect system of justice. Innocent people are convicted all the time in the Commonwealth of Virginia. It is up to us as the government that if we're going to deprive someone of an innocent person of their liberty, then there should be a way to fix it and to make sure the actual criminal is convicted. This bill does that. And so under that scenario, that is Senate Bill 777.
All right. Any questions of the patron? Anybody wish to speak in favor of this bill?
Mr. Chairman, Steve Pearson on behalf of the Innocence Project. This bill has been discussed with many of you in some detail, and it has changed a little bit over time with reactions coming back from individual members. We have a new substitute today, and one of the things that I'd like to do is to review the changes between the bill as introduced and the substitute. But before I do that, let me just say that nobody, I don't think in this room or in the General Assembly, wants to see innocent people remaining in prison when there's evidence of that innocence. The question really is, how do you get them out, and when do you do that? We've reacted in the past to DNA evidence with writs of actual innocence, but those writs require affirmative proof of actual innocence by clear and convincing evidence. That doesn't fit in these cases because these individuals were frequently convicted primarily as a result of the scientific evidence which has since been debunked, or because of the lack of scientific evidence which might show their innocence at the time. So the existing evidence couldn't be tested, but the instrumentation, the analytical methodology now exists to do that. And so you can get them out of prison if you would undertake these tests and show the evidence. At the same time, the other post-conviction remedy, habeas, doesn't work very well either, because although many of us in this room sort of grew up in an environment where habeas was discussed in the media all the time, and the general perception was that the courts were overwhelmed with these habeas petitions, it was true. But back in the 90s, federal habeas was fixed, state habeas was fixed, and the Supreme Court came along and said only one habeas petition. So habeas is really no longer a problem, but it has, as a result, gotten such a short statute of limitations. 1 year or 2 years in the state system, depending on where the case ended up, and 6 months or 1 year in the federal system, which follows immediately after the state system, depending on whether the petitioner has counsel or not. Although habeas would be a reasonable remedy for this type of thing, it just really, as a practical matter, doesn't exist. So it's our suggestion that Virginia adopt this new remedy, which fits the circumstances and is limited to scientific evidence, forensic scientific evidence. Since many of you were aware of the provisions of the actual bill, let me detail for you, catalog exactly what the changes are that we've made. And I'm also prepared to answer any questions about the bill. And then I have Michelle Feldman from the Innocence Project here, who can talk about what the Innocence Project has been doing.
All right. Somebody else is more than welcome to speak. We're almost out of time.
Quickly then.
Hang on, Steve.
The substitute is patterned very closely to the writ of actual innocence for non-biological evidence. The differences from the bill as introduced, the substantive differences, are that we have gone to a limitation to defined offenses only at lines 17 through 19. Only one writ is permitted unless based on distinguishable evidence. That's line 32. Discredited evidence is defined on line 86. You file in the Court of Appeals rather than in the Circuit Court. That's line 30. And that takes the Commonwealth's attorneys out of the picture insofar as placing duties on them to respond. And the courts can act summarily without a response by the Attorney General. Line 110 has a delayed effective date, giving you all the opportunity
Steve,
to.
we're out of time.
Okay.
And I appreciate that. We're going to hear from opponents, and I'm going to ask the Crime Commission afterwards.
Mr.
I
Chair.
know you all looked at this.
Mr. Chair.
Who's that?
Chap. Peterson.
Can you hang on a second, chap? The Crime Commission looked at this in 2016 and looked at the benefits and challenges. And after both sides have spoken, I'd like maybe the Crime Commission to tick through those issues. Senator Peterson.
Yeah, very quickly, Steve, let me ask you the question. As I understand, the legislation is to get at criminals that were convicted where they did not have access to certain scientific evidence. And if the petition is granted by the Court of Appeals, that there would then be a retrial, I assume with access to the scientific evidence. Is that effectively what this would do?
Mr. Chairman, Senator Peterson, the retrial would be in the discretion of the Commonwealth. The remedy sought would be the vacation of the conviction.
Okay, one follow-up question.
Senator Peterson.
How do we, and is there time limits, and I'm not seeing them, how do we make sure that the prosecution still has access to the witnesses, the victim? I mean, basically, that they're able to put the case back together that they presumably tried 2 or 3 years previously?
Or 10 or...
Mr. Chairman, Senator Peterson, it might be longer than that. And there will be some problems that I think the bill is broad enough that it enables the court to address those problems and enables the prosecution, the Commonwealth's attorneys, to get in and make those points if they wish.
All right, let's hear from those who have concerns about this.
Mr. Chairman, Chuck Slimp, Commonwealth's Attorney for Wise County, City of Norton. On behalf of the Commonwealth's Attorneys Association, we oppose this bill. There's a host of issues with the bill, and I haven't had time to look through the substitute completely, but number one, this opens Pandora's box and allows evidence that might not necessarily have even been admitted at trial and used to form a conviction to be relied upon here to form the basis of a new trial or setting aside a conviction. This also extends to individuals who confessed their guilt in open court and pled guilty, rather than those individuals who simply pled not guilty or were found guilty. It has a fiscal impact, being that the individuals who are granted a petition would be appointed an attorney. It has a significant effect of lowering the standard of proof from clear and convincing evidence now to a preponderance standard. And then it essentially allows unlimited attempts to undermine a conviction, which allows for victims never having closure, never having the assurance that this case is going to be over with. It allows all sorts of opportunities to, quote unquote, game the system. And so additionally, we would point out that there are other options. There are options available, whether it be habeas, federal habeas, state habeas, the writs of actual innocence, and pardons from the governor. And I specifically take issue with and fundamentally disagree with the statement made previously that innocent people are convicted all the time in Virginia. That's just not true. Thank you.
Mr. Chairman. All right, thank you. All right. Steve, do you have something you want to say?
I do, Mr. Chairman. I should point out to
Colin up here.
I should point out to the committee, Mr. Chairman, that habeas is not and has never been a remedy for a person who is actually innocent. You cannot allege as a grounds in a habeas petition that you are actually innocent. It's not recognized. The existing writs of actual innocence are essentially obsolete now. The DNA writ, for example, only applies if you could not have had the evidence tested for DNA at the time. This worked for the old cases before DNA was being used forensically, but these days you would be fundamentally prohibited from using that particular writ. The non-biological writ, again, I don't know of any case where that has been effective without the Attorney General agreeing to the granting of the writ. Otherwise, it simply doesn't apply.
All right. Colin, you want to come up?
Good morning, Mr. Chairman, members of the committee. Colin Drabert, Staff Attorney for the Crime Commission. As the Chairman stated, the Crime Commission had examined this issue back in 2016 as part of a study request, which was submitted by the Mid-Atlantic Innocence Project, looking at a statute out of Texas referencing habeas corpus. So we examined that statute as well as Virginia's habeas laws and the actual innocence statutes in Virginia. And ultimately there was no policy or legislation endorsed by the Crime Commission, but there were various benefits as well as challenges the Crime Commission noted in terms of implementing a law like this in the Commonwealth. As previously noted, in terms of the benefits, this would fill a gray area in the law. As Mr. Benjamin stated, habeas is strictly limited to procedural type due process issues. Actual innocence is for individuals who are actually innocent of a crime for which they've been convicted. This falls in a gray area where they may or may not be innocent of the charge, but the scientific evidence may have changed in the time period since their conviction. In addition to some of the other benefits, there are very strict statute of limitations which apply in regard to habeas claims. This would alleviate some of those statute of limitations issues because scientific evidence can take some time to change. Would provide an opportunity for individuals who were convicted under older scientific evidence where it's regarded in the field that the science has changed, for the opportunity for a new trial to dispute the science which may have underlaid their convictions. There are certain areas of science which are more in dispute than they used to be, such as the hair analysis samples, certain bite mark analysis, and certain arson investigations. In terms of whether the court system would be flooded as a result of these claims, it was estimated that because science can sometimes take quite a while to change the field of belief in the validity of science, that there would not be a flood of claims flooding into the Court of Appeals if this legislation were to pass. However, on the challenges side, some of the issues identified, we had hoped to see what was going on with Texas with their statute at the time we conducted this study. There had only been one case that had gone through and been decided, so that did not provide a great deal of insight as to how courts would address these challenges. But one issue with which the court may struggle is determining when exactly a field of scientific evidence has changed, which could also lead to a battle of experts within the appellate realm as to one expert stating that science has changed, another expert stating no, that science has not in fact changed and that the past science remains valid, and that would ultimately lead to the Court of Appeals to be making decisions on whether in fact a scientific field itself is no longer valid or not. Another point which was previously brought up is because of the time that it can take for a scientific evidence to change, many of the witnesses or evidence from that previous trial may have gone missing or may be very difficult to locate. And finally, in terms of it may be difficult to limit the number of petitions. Currently, the biological writ petition is limited to one, where an individual may file a petition. It may not be successful, but years down the road, it may be determined that the science has changed. How do you limit petitions on a certain scientific field when that science is constantly evolving? So while there were many benefits to this study, there are certain type of legislation, there would also be many technical challenges in terms of implementing it within the Commonwealth.
All right. Thank you very much. I appreciate that. Anybody have any
Miss-
questions for
yeah.
Colin before he leaves? Senator Peake.
Mr. Chairman, if the defendant court appointed and then there's some discrepancy on the science, who pays for the defendant's expert? Would that be covered under, would we have to pay for it?
I am not 100% certain. I believe some of the scientific evidence in terms of the DNA analysis statutes, I believe if a motion is filed and the court grants DNA analysis, that evidence is commonly tested by the Department of Forensic Science, so the state would bear that cost.
No, but if there's a fight as to whether or not a science is now discredited and you need an expert on each side, who?
And I am not certain as to who would pay
Charles
for
or Steve?
that.
You have any insight?
The cost would be borne by the petitioner. It would be a prisoner in Department of Corrections who has maintained his innocence, who then seeks to utilize the opportunity to prove his innocence sufficiently to get a new trial. He would bear the burden of developing the scientific evidence necessary for the petition and for the burden of proof.
Okay, thank you, Mr. Chairman. Another question.
Senator Peake.
And then for Steve or Mr. Stanley, the patron of this bill, and what you have changed in the original, they had to have pled not guilty, no contest, or offered plea. In this new substitute, anybody can do it. Is that correct? Even if they pled guilty?
It's the same, Mr. Chairman, in both bills. Whether you've pled guilty or not guilty, this remedy exists.
If you look at B, you look at B and the one I had last night, and you look at B that I was given this morning.
That's correct. B on the substitute at line 29 speaks to a petition of a person who was convicted.
Was convicted, but in B, and the one I had last night said a person who was convicted upon a plea of not guilty, plea of no contest, or offered plea. That is not in.
That's correct, Mr. Chairman. Senator Peake, what this substitute does is take out unnecessary words, because you can be convicted on a guilty plea, you can be convicted on a not guilty plea.
But the B that I had last night did not allow you, if you entered a guilty plea, you did not come under this section.
Mr. Chairman, Senator Peake, I don't think that's correct. The original version that I looked at covered all pleas, not guilty, guilty, nolo contendere. In any event, the bill before us.
I can tell you, I'm looking at it right now, and it does not say anything about anybody who entered a plea of guilty, no contest, or offered, but a straight-up guilty plea is not covered in the one I had last night.
Mr. Chairman, on line 27 of the version, the original version, line 27, it provides that the person may petition who has been convicted of a felony upon a plea of not guilty, a plea of guilty. It should then say, or nolo contendere.
It doesn't.
Well,
it says a plea of guilty nolo contendere, which is an actual phrase. That's a legal phrase. That's guilty, no contest. All right, but if it's supposed to have a comma there.
There is no such plea.
All right.
Yeah, there should be an or inserted there. That was a drafting error.
Okay.
Thank you, Mr. Chairman.
All right. You want to wrap it up?
Yes, sir, Mr. Chairman, members of the committee, I'd just say a couple things. When we've seen the enacting of this statute in Texas, over 5 years, there have only been 25 petitions. In California, there have been 13 over the 5 years. And, Mr. Chairman, the most stark fact that I think we all need to consider here is this. In Virginia, with those 11 wrongful convictions that I talked to you about, based on flawed science, the real perpetrators of those crimes that were identified went on to be convicted of 6 additional violent crimes, including 4 murders. That is significant. And that is the reason for this bill. And I thank you, sir.
Senator Chafin.
Mr. Chairman, question for the patron. Senator Stanley, it seems that some committee members have a little heartburn with the idea that this applies to all convicted defendants. Okay, and so my question to you would be, would you consider an amendment that would trim the bill down to deal only with those who had entered a plea of not guilty and subsequently been found guilty?
Or an Alfred plea? Is that what you're talking about? Because an Alfred plea in its essence is saying, I'm not guilty, but I'm taking the deal because it's so sweet, so good.
I don't have any choice. I would agree with that.
Or an Alfred plea.
I have no problem with that.
All right, is that a motion?
I'll make that motion.
All right, yeah, Steve, Charles, you okay with
We can
that
supply that
language?
language, yes, sir.
All right, is there a second?
Second.
Any discussion, questions? All in favor of that amendment indicate by saying aye.
Aye.
All opposed?
No,
All
no.
right, let's open the roll. On the amendment.
Ayes 11, noes 4.
All right, the amendment is made. Is there a motion on the bill?
Mr. President, Mr. Chairman,
Senator Peterson.
I also have an amendment, and I'm looking at line 91, which is the standard that the court would actually look at in terms of whether or not to vacate the conviction, and right now it's preponderance of evidence on line 91. I really think that ought to be clear and convincing. And I would offer that as an amendment. It would have to be clear and convincing.
All right, is there a second? All right.
I second it.
All right, motion has been made and seconded to add clear and convincing.
Substitute clear, yeah.
All right, all in favor signify. Steve, do you have something you want to say?
Mr. Chairman, question.
Sarah, start
Just
it.
briefly, is the burden of proof where this is in paragraph H referring to the Court of Appeals?
That's where it's heard.
Okay.
Yeah.
Are there any other instances where the Court of Appeals has a fact-finding function that anyone is aware of?
The current petition for actual innocence based upon other evidence, non-biological evidence, is heard by the Court of Appeals.
And Mr. Chairman, I think it's referred back to the circuit court for the findings of evidence.
That's correct.
For any factual findings, additional factual findings.
Mr. Chairman.
All right, Senator McDougal.
Mr. Chairman, I very much respect what Senator Stanley has been trying to do, but there's a number of things that we have not discussed that this bill is not going to alleviate my concerns on. What do you deal with victims and their notification? How long are these cases open? And Mr. Chairman, I might have been amenable to even having a conversation about what specific evidence we think is no longer scientifically valid at this point and us making that determination. But I am not comfortable with leaving victims wandering around in the wilderness, not knowing the result of the case, because somebody's going to argue that this particular scientific evidence is no longer valid or is changed. And so with that, Mr. Chairman, I'd make a
Mr. Chair.
motion to PBI.
I think I still had a pending amendment.
No, it died for lack of a second.
No, we got a second.
Oh, okay.
Peak
Did we
seconded.
not vote on that?
We did
All right.
not.
All in favor of adopting that amendment signify by saying aye.
Aye.
All opposed. All right,
No.
clear. All right, let's open the roll on the clear and convincing evidence amendment.
This is an amendment.
All right,
Ayes
the
12, noes
amendment,
3.
the amendment is adopted. Senator McDougal
Renew my
moves
motion to PBI.
that the bill be passed by indefinitely. Is there a second? And seconded.
Substitute motion.
Really?
Yes.
Okay.
That the bill be reported.
All right.
Second.
Substitute motion properly seconded is that the bill be reported. Clerk will open the roll.
Ayes 9, noes 6.
All right, the bill is reported.
Mr. Chairman, there's one technical amendment that should be added to the bill on line 42.
All right.
And if you proceed with it, then you would add ED after the word discredit to give it the correct tense, and you would insert the word was between the words evidence and presented. Those are simply technical.
All right, Senator Stanley, you want to move to reconsider the
move.
vote by which the
I so move.
bill was reported? Is
Having
there a
voted on the
second?
prevailing side,
All right,
I move the reconsideration of the vote.
all in favor of reconsidering the vote signify by saying aye.
Aye.
All opposed? All right, Senator Stanley, you want to move those technical
I would
amendments?
move those technical amendments.
Technical amendments have been moved and properly seconded. All in favor signify by saying aye.
Aye.
All opposed? Senator Stanley, you want to move to report the bill?
Why not?
All
Let's
right,
do that
is there a
too.
second? All right, clerk will open the roll.
Ayes 9, no 6.
All right, thank you very much. Senator Stanley,
Yeah, just
second bill.
very quickly.
We're going to have to roll through these.
I'm going to roll through it. Senate Bill 779 is, we understand as attorneys that there are covenants not to compete that exist between employer and employee. As we know, in Virginia, that's limited by time, place, scope, duration. Sometimes those covenants not to compete also have consideration embedded in the contracts, added compensation to the person, the employee. In the medical profession, those covenant not to competes have a problem. There's a problem in the sense that, let's say in a physician's practice, it's a corporation, there's a covenant not to compete with a doctor, and the doctor's leaving the practice, can't compete within, let's say, a 10-mile radius, 15-mile radius of the practice. There may be other concerns. What happens is that that doctor who may have obtained patients, those patients don't have a choice to maintain their relationship with the doctor due to his contract and covenant not to compete. So what this bill does basically is it creates that those contracts between physicians and the medical fields and their employers are void, and that's the bill.
Mr. Chair.
Let me just say one thing, and then I'll hand it over to Senator Peterson. Living in a community with a vertically integrated healthcare provider that really has a monopoly in the community, I want to say that, this addresses a real problem. I've had a significant change of heart on this bill since it came through the Commerce and Labor Committee. And, if we've got a community in which we've got one hospital that, for example, used to say, we don't hire physicians and don't employ physicians. Now they employ every physician in the community almost. And a doctor chooses to leave that hospital and they can't stay there. And it hurts nobody but the patients. And it creates a significant hardship for particularly rural communities where we're having a hard time providing access to care anyway in those communities. And, this is part of the greater healthcare issue. And as I've told a lot of folks, this is a complex issue with no single solution. And unless we get a lot of help from the stakeholders in this, there are going to be some things that come out of the General Assembly that they ain't going to like, but make a whole lot of sense. And if we've already said as a General Assembly and as policymakers that it's important that attorneys and clients, in their relationship, that clients be able to pick their own attorney, and we don't allow non-competes for attorneys, I think healthcare providers are even more special in their relationship with their patients, and we ought not allow healthcare providers, particularly in these rural communities or vertically integrated communities, to dictate who my doctor is. So, I think I've got to change of heart about this. Senator Peterson.
I'm just going to say, I love this bill. The legislation, not you, Stanley.
Oh, all right.
But
thought we'd go for coffee later.
All right, maybe we will. All right, that was I won't make any comments. All right. The only thing is, I think there's some language on the back end of it that would allow someone to sort of backdoor what they can't do through the front door, which talks about suing for for damages from competition. I think I referenced that to you earlier. So at the appropriate time, I'd like to make a motion to strike out that last sentence on
38 through 40.
Now would be a good time for that.
I'll make that motion then. Actually, I was going to take out the last sentence, line 35 to 37.
Mr. Benjamin, you had an opportunity to cogitate over that and come up with appropriate language. Apply your scalpel appropriately.
Indeed, Mr. Chairman, I would have suggested that beginning on line 31 with the word however, that the language from however to the end of line 37 be struck.
I'll make that motion.
All right,
So from 31 all the way to 40, sir?
Yes,
Okay.
it's been moved and
to 37.
Senator Stanley, you want to second that?
Second.
All right, it's been moved and seconded. Any discussion of that amendment? All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is adopted.
Mr. Chairman,
All right.
also on line 28, the words "in the practice of" should be struck and insert the word "to." So it reads, "the right of a physician to practice medicine."
All right. Senator Stanley, you want to move that?
So moved.
All right, it's been moved and seconded. Any discussion? All in favor of that amendment signify by saying aye.
Aye.
All opposed? All right, now, I know that there's some people who have some strong views one way or the other. Anybody wish to speak in favor of this bill? Anybody wish to voice concerns about this bill?
Slow down.
A lot of people here.
Mr. Chairman, members of the committee, Brent Rawlings for the Virginia Hospital and Healthcare Association. Spoken to this bill previously and expressed our concerns with it. We think this is highly problematic for hospitals, health systems, and also physician practices. These agreements are not just used by hospitals and health systems, they're also used by physician practices. And what they are is they're a strong recruitment and retention tool. I come at this from a little different perspective. In my previous life as a healthcare attorney, representing hospitals and physicians on these matters, we realized that we need to have a cardiology line, for example, in a rural community. You can't have cardiology without a cardiologist. How do you get a cardiologist to move into a rural area? Sometimes you have to sweeten the pot a little bit. And so you provide them a good salary. You also pay their medical school, all their fees for medical school, their tuition costs. You recruit them to come to the area, you invest in that physician. They make a commitment to the community to provide services. In exchange for that, they agree not to open up shop and compete directly with that physician practice or hospital in the community. That's part of the consideration that's given. If the physician decides later on he or she wishes to breach that contract, they have that right. That's a business decision that does not interfere with the patient relationship. The non-solicitation or non-compete is there. There's nothing that can prevent any practice or hospital from preventing a patient from going to seek services from that physician at a later date. It also pointed out that there are existing protections under the law that don't require changes in the statute. The courts have consistently applied a reasonableness test on this, a three-part reasonableness test. The scope could be no greater than necessary to protect the legitimate business interests of the employer. We just talked about those. Not an unduly harsh or oppressive restraint on the employee's efforts to earn a living. They've got options. And the third part, consistent with sound public policy. I think it's sound public policy to make sure you have adequate physician coverage in a community. So also the courts, I would add, when there's any ambiguity in these clauses, they are viewed in favor of the physician and against the employer. The employer has the burden of proof to show the reasonableness on this. So the law is pretty consistent in the state. This is a longstanding business practice to allow these. It is done routinely, and the courts have enforced it to protect any unreasonable provisions. And so we're opposed to this legislation.
All right, thank you. Yes, sir.
Mr. Chairman, committee member Sam Grossman, representing Pediatrics Medical Group and American Anesthesiology of Virginia. We employ about 190 physicians in the Commonwealth here. We also rise in opposition to Senate Bill 779 for similar reasons as stated by Mr. Rawlings. As a large private employer of physicians across the Commonwealth, we rely upon these same restrictions to help and assist us in recruitment and retention of physicians across the Commonwealth. And thank you for the opportunity to be here today and provide these brief comments.
Let me ask you, and I assume the hospital, I know you don't like this. Would it help, I mean, both of you, and I think we've got a little constitutional issue with this, at least as currently drafted, help help you if it's prospectively applied only to new contracts? Not at all?
I would say no. Again, I mean, this is a
I don't-
recruitment
I know you
retention
won't
tool.
support it, but I assume you would want at a minimum that kind of an amendment.
I think that would be a significant legal challenge or problem if it were not done.
Okay. All right, Senator Stanley, you object to an amendment making it prospective, apply to prospectively to new contracts?
Mr. Chairman, I think that's how we always, in the law, act. But I don't have a problem, whatever the court, I mean, whatever the committee's desire is.
Senator Peterson.
Well, my position would be these contracts are unenforceable right now. So I don't think you can prevent a physician from practicing medicine, and I defy you to show me a court order that says otherwise. So I disagree that these contracts are enforceable now. So I would not, I just think courts have always said that a covenant not to compete has to be in the public interest. That's
Public
one of the
interest.
4 prongs. And my position has been, when you prevent someone from practicing medicine in a certain area, that is against the public interest. So I don't think that there's any need to make this prospective. I think it is the law right now.
Mr. Chairman, I will do whatever this committee, I find that to be a friendly amendment if you think so. So I will do whatever this committee believes is the right thing.
Well, I can't make a motion, but if anybody wants to make that motion to apply it prospectively, go ahead. Nobody wants to make that amendment. May doom this piece of legislation.
So move.
All right, it's been moved and seconded to amend to have a prospective application. All in favor signify by saying aye.
Aye.
All opposed?
No.
All right, let's open the roll.
John.
All right, let's close the roll.
I can't revote, yeah. Ayes 9, noes 6.
All right, the amendment is made. Bill is before us. Senator Stanley, you move the bill.
I'll move to report.
All right, it's been moved and seconded. Clerk will open the roll.
Whew.
Ayes 7, noes 8.
Bill fails to report.
Thank you, Mr. Chairman.
Mr. Chairman, I have a motion, having
Oh, that's fine. Go ahead.
having previously voted on the prevailing side on Senate Bill 308, Senator Stewart's bill, I'd move that we reconsider that vote.
All right, is there a second? All right, it's been moved and seconded that the vote by which Senate Bill 308 failed to report be reconsidered, and it died on a 7-7 vote, is my recollection, and still within the breast of the committee. Is that right, Hobie?
What is the bill, Mr.
308?
What's it do?
Under the influence.
Okay, it was passed by indefinitely.
Off the highway.
All right. All right, all in favor of reconsidering the vote signify by saying aye. Aye. All opposed? All right, the bill is back before us. Senator Stewart.
Thank you, Mr. Chairman. You want me to kind of do it
Yeah,
again?
that's fine.
Mr. Chairman, Senate Bill 308, the bill we discussed, had to do with a DUI on your private property or curtilage, and in trying to redefine where you could actually be charged with it, I think my bill went a little too broad. And so what I've asked is I've talked with the members of the committee, frankly, on both sides of the aisle, and there seems to be a consensus that folks would be okay. And I talked to the Commonwealth's attorney from Waynesboro, who I thought had a great suggestion, to narrowly define this bill to exempt your residence or the curtilage thereof, or your property or the curtilage thereof, so that you wouldn't be impacted if you were in a parking lot at Walmart or Busch Gardens, as others had talked about. The officers would still be able to arrest. As y'all recall, the Seraphin case now essentially says you can be charged and convicted of a DUI almost anywhere. And I don't think we want to allow that if you're in your own yard or the curtilage of your yard. So, Mr. Benjamin has an amendment that he's so graciously prepared, and I think that if he could report that amendment, I think everybody's okay with that, or maybe I misread it.
Mr. Chairman, Senator Stewart, the following language would be added at lines 28 and after line 47. That language would be, "This section shall not apply to any person driving or operating a motor vehicle on his own property or the curtilage thereof."
Mr. Chairman,
Senator Peake.
a question to Mr. Benjamin. Does that mean you could then drink beer while you're cutting your grass and baling hay?
Absolutely.
Okay.
Well, Mr. Chair, I've got,
Senator Deeds.
what if you, a property that where a direct easement has not been granted, and the Commonwealth has a prescriptive easement through your property on a public, it's a public highway, but it's still your property through, they only have the easement by prescription. Would this language prevent you from being charged with DUI while you're on a public highway that is on prescriptive easement through your property?
Mr. Chairman, I think I can answer that. Are you talking about a 1932 Bird Road Act road? No, it would not. You would not be exempted from a 1932 Bird Road Act road. You would still be subject to being prosecuted and convicted.
Tell me why.
Because the statute says 46.2-100 defines a road as all the areas within the ways for that.
Well, it does, but tell me why this
Senator
language.
Deeds.
Tell me why this language would not override that.
Because this would be on your property and the curtilage thereof, not the highway. I'm relying on Mr. Benjamin.
Oh, thanks. All right. Have we adopted that amendment? All right.
I move the amendment, Mr. Chairman.
All right, the amendment has been moved and seconded. All in favor of the amendment signify by saying aye. Aye. All opposed. All right, the bill is before us. Hang on. Let's hear from the Commonwealth's attorneys and see whether they concur with Senator Stewart before we roll with this.
Good morning, Mr. Chairman. David Ledbetter, Commonwealth Attorney of the City of Waynesboro, here on behalf of the Commonwealth Attorney Association. I have not seen the amendment. I did make that suggestion to him as an individual Commonwealth attorney about that change to the curtilage, because we were talking about the one case where the man was in his driveway and was arrested. I don't know about the implications to other portions of property or private property, but I did make that suggestion. But I'm really not able to speak to the amendment at this point.
Do you want 5 or 10 minutes to look at it before we vote on it?
If I could, yes,
all right.
please.
Without objection, this will go by temporarily. At this point, I've got a handful of people here on a bill, and I'd like to take up Senate Bill 545, if Senator Stewart would mind.
Yes, sir. Senate Bill 545. Substitute, thank you. Can we get a motion on the substitute?
So moved.
Second. Motion properly seconded. All in favor, please say aye. Aye. Opposed, no. The ayes have it. The substitute is before us.
All right, Mr. Chairman, members of the committee, this bill is intended to address an issue that has become increasingly troublesome over the course of the past few years. And I've practiced law for 30 years. I spent my first 15 years as an insurance defense lawyer. And about 15 years ago, I don't know, 17, 18 years ago, there were some insurance companies that started to tell me as a lawyer, we would prefer for you to use a certain court reporting company. And, it was expressed as a preference. And very often I just said, I'm going to use my court reporter, and the court reporter I'm used to, court reporter that has served me for years and years, and I ignored it, and I never got fired. I never was told I had to use that court reporter. But over the course of the past 15 years, many of these insurance companies and corporate parties have been marketed by certain national firms. They are firms that provide court reporting services plus all kinds of litigation support services. And they have entered contracts with large insurance companies and with corporations that are frequently the subject of litigation. And pursuant to these contracts, they require that in all of their cases, they use this litigation support firm or this court reporting firm. And what happens is, if I am handling a case adverse to this party, I go to that deposition, and I get a bill at the end of it that has all kinds of additional charges, this litigation support package. I have no idea what a litigation support package is. I get nothing but a transcript from these firms. I find that the charges for a plaintiff are grossly out of proportion to what I am accustomed to receiving from my local court reporter, who I've used for years and years. I find that instead of 25 lines per page, I have 23 lines per page, which increases the number of pages for which I'm paying a higher price for copies. I find that the font is larger, and I have seen time and again bills that are shocking. I had one bill sent to me from a lawyer who had a 4-hour deposition with one of these national firms. He got a copy of that deposition and was charged $4,000 for that. $4,000. Now, these lawyers ask, what are you charging the other side? And they're told by the lawyer on the other side, I have no idea, because I never see the bill. It doesn't come to me. I don't pay it. It goes straight to, insurance company A. It turns out that insurance company A has this contract. And the model is pretty clear that these companies that are providing this range of services has contracted with a party to the litigation, Now, court reporters traditionally have been neutrals in these cases. And when I take a deposition, every time at the end of it, I instruct the witness, I say, at the end of this deposition, you've got to agree to waive your signature or sign the deposition. It's customary to waive because this court reporter is independent. This court reporter is not employed by the other side or by me. They're just certifying to the best of their ability that it's going to be an accurate transcript of your testimony. But that's not the case any longer if they are actually engaged under a contract with an insurance company or party to the litigation, and they are shifting the costs to the other party and are not telling you or giving you an opportunity to purchase those same services at the same cost. Take, for example, the day in which we've got 4 depositions, 2 of the other side and 2 of my side. And I show up just because the defense noticed the depositions first, and I assume I'm going to use their court reporter. And I order, all 4. I order the 2 copies and the 2 originals, and I get a bill for my originals, and I say, well, wait a second, this is pretty darn high. Are you charging the other side the same amount? The court reporters won't tell you what they're charging the other side. It's just fundamentally not a fair arrangement. Now, what this bill does is this bill basically says, look, we're going to restore the status quo ante. restore court reporters to the position that they used to be in which Senator Peake or Senator Sturdivant or Senator Stewart or Senator Peterson or we're the ones who hire the court reporters, not a party to the suit. And that the court reporters are not allowed to make contracts with insurance company A or insurance company B to do all of their cases and to shift the costs to the other side. Now, if I go to a court reporter and say, look, I've got a huge series of cases, and I want you to do all of these cases for me, and I'm hoping that you can cut us a break and maybe charge us $1 less a page for those depositions. A court reporter is perfectly free under this bill to say, sure, that's fine, but they've got to offer the same deal to the other side. It simply is leveling the playing field, making sure that that parties aren't employing these court reporters and restoring the court reporters to the position that they used to be in which they were essentially officers of the court. They were neutrals, and we knew that they were unaffiliated with either side, and we would retain them, and they would provide those services equally to both sides and treat both sides just the same, charging them the same. It is a common sense piece of legislation that frankly has passed in 35 states because of these challenges. Now, I hear that opponents, a couple of these large national litigation support firms say this is going to put us out of business. It's passed in 35 states, and they haven't been put out of business. And by all accounts, they're thriving. And the litigation support services that they are providing, they're valuable services, but they're not court reporting services. And they shouldn't be able to merge court reporting into the package of services that they package and sell to insurance companies at the expense of the opponents. This is not a plaintiff's bill. It's not a defense bill. If you ask lawyers around the state, plaintiff's lawyers will almost universally say, yeah, I've been gouged as a result of this. Defense lawyers will tell you, I think this is a great bill. I hate the fact that the insurance companies are telling me who I have to use, and I cannot use the court reporters I trust and value and have used for years and years. If you look at the handout that I've distributed, you will see plaintiffs' lawyers and defense lawyers from across Virginia who support this piece of legislation from all corners of the state. And Mr. Chairman, I just submit that this is a common sense piece of legislation that simply restores the status quo ante and requires that court reporters treat lawyers and parties equally. That's it.
Mr. Chairman. Mr. Chairman, this way.
Senator Peake.
Thank you. Question for the patron. Senator, doesn't number 2 on page 2 take care of that by saying everything should be treated the same? So does it matter whether or not there's a contract?
Well, I would say yes, it does. If you think it's okay for a court reporter to have a contract with a party, I think that's antithetical to the position in which court reporters have traditionally stood. If I'm representing, Volkswagen, and the court reporters are hired by Volkswagen and are under a contract with Volkswagen, they're going to have a connection or a bias and lack the appearance of impropriety. I don't believe that court reporters ought to be contracting under a contract with one party or another to the case. And lawyers are the ones who ought to be hiring the court reporters, not the parties.
Senator Obenshain, to that point, In fact, it would create a bias because they have a contract with one party and they're providing a service to both. And as such, doesn't that create an inherent conflict of interest?
I would submit it does. And when a court reporter is hired by a lawyer, frankly, they're hired by both law firms. They have a contract with both parties to the litigation to provide those services to both.
Mr. Chairman.
Senator Peake.
And then along those lines, let's say one company attorney does work with a company and negotiates a lower rate, and the plaintiff gets the benefit of that rate. Is it not beneficial to the plaintiff's attorney as well?
Well, what this says, under the current system, the opposing party doesn't get the benefit.
But what does number 2?
With this bill, it requires that both parties be treated equally.
And then my question, Mr. Chairman.
Senator Peake.
And so doesn't number 2 on page 2, line 41, make sure that happens no matter what?
It does, but it does not address the inherent conflict of interest that number 1 addresses.
Well, and Senator Obenchain, I guess I still have a concern with that provision because despite the fact that you're treating both sides equally, the party that has the contract is going to have an incentive to help that party to keep getting that business. So that's what concerns me, and I guess that is addressed more to Senator Peake's question. But if that court reporter that has that contract with the insurance company, despite the fact that they have to treat it fairly, it puts them in a conflict of interest position because they're going to want to please that insurance company and continue to get all this business.
Yeah, and without number 1, the parties, the defendant, or excuse me, the plaintiff may not have that confidence in the integrity of the system.
And that's what concerns me. It's the contract that creates a conflict of interest.
And this addresses that.
Exactly.
All right.
Okay, other questions of the patron? If there are no questions, are there those that would like to speak in support?
Mr. Chairman, good morning. Mark Dix for the Virginia Trial Lawyers Association.
Good morning.
On behalf of our 2,000 members, which are comprised of plaintiff and defense lawyers, and we're the largest group of the consumers of these services, next to probably the Virginia State Bar, we support this bill. As Senator Obenchain mentioned, court reporters are supposed to act as officers of the court, fair, impartial, beyond reproach. But these agreements, which are entered into secret, are anything but that. As a personal aside, I have likewise been a victim of one of these arrangements. My client had to pay more for a copy of a transcript than the other side did for the original of it. This bill will restore transparency and protect the integrity of the role court reporters are supposed to play in our civil justice system. Thank you.
Thank you. Yes, ma'am. Come on up.
Good morning. My name is Karen Hart, and I've been a court reporter in Virginia for the past 30 years. I'm here today with Virginia Court Reporters Association President and a few other court reporters as well. And I rise in support of the bill on behalf of them as well as attorneys in Virginia, many of whom have contacted us about this bill. We could have had 50 or more court reporters here, but the courts would have to shut down because there wouldn't be court reporters there today. So I hope I speak well. The primary issue that this bill addresses is cost shifting. The question of protecting the impartiality of the court reporter for the benefit of all the parties. Under this arrangement, which Senator Obenchain described, frequently the national agencies do call on Virginia court reporters to cover this work. We are required then to email our transcripts to that agency, whether it be in New York, New Jersey, or D.C. Our work often involves highly confidential matters. We forfeit the oversight of our work, where it is archived and how it is billed. Sometimes our margins and lines per page are changed, as referenced earlier, so that instead of our transcript being 100 pages, it now turns into 120 pages. Court reporters, we don't want to be part of this behavior. We consider ourselves to have a duty to be impartial, and that's why the passage of this bill is so critical. The second issue that I'm here to address are the complaints among the attorneys who find themselves on the other side of this contracting agreement. These attorneys and their clients particularly need your protection. The parties are unaware of the terms involved and the benefits the opposing party are receiving, yet they are bound by the agreement entered into by their opponent. The other side should not have to pay an unfair rate compared to the opposing counsel, and this is where the cost shifting comes in. Even our opposition admits that restrictions on third-party contracting should be imposed where there's a credible evidence of a significant risk of harm. Please carefully review the letter by Mr. Haddad in your folder. We could have submitted many more letters, but sometimes one explains it very well. Many prominent attorneys have contacted us to voice their support for this bill, and we feel compelled to tell you many defense attorneys have offered their silent support because they cannot go on public record for fear of losing their insurance clients, but they are behind us. Some real-life examples.
And if you could just kind of finish up, because
I'm done.
we're out of time, and there
I'm
are other
sorry.
folks who'd like to speak.
Okay.
You want them to vote for it?
Yes, I was
You
going to
like
give you
the
some
bill?
real-life examples. If you have any questions, I'm happy to go there.
Thank you.
you.
Yes, ma'am. You'd just like to register your support and tell us who you are.
I do. I'm Carol Naughton. I'm the president of the Virginia Court Reporters Association, and we support this bill, and we're asking you to pass it and follow in the footsteps of the 35 other states that have also adopted this
Thank you.
language. Thank you.
Yes, ma'am.
Hi, I'm Donna Linton. I'm a court reporter in Ashburn, Virginia. I'm also secretary on BCRA, but I just want to say it's impartiality. It's just not a fair playing field, and it's making it where a plaintiff's attorney, you know, I know a lot of attorneys here are senators and working attorneys, but you know, it's not justice for a plaintiff if they're not going to know what they're going to have to pay for their legal fees, and how are they going to get justice for their cause if they're not going to, if they're going to be gouged like this. So,
Okay.
and that's what I'd like to say. Thank you.
Anyone else like to register their support? Okay, if not, those that would speak in opposition, come on up.
Mr. Chairman, members of the committee, I'm Clark Lewis at Travis Sanders Strategies. I represent Esquire Deposition Services, U.S. Legal Support, Magna Legal Services, and Veritex Corporation, and we respectfully oppose this bill. I'd like to step back just real quickly to 1990 when I first started practicing law. I agree with Senator Obenshain. That was a time when you knew the court reporters, you knew the local attorneys. My firm was 90 folks. We practiced in Richmond. Go back 27 years now, my firm is 660 lawyers. Our lawyers practice throughout the East Coast in the United States. We have third-party administrative clients who manage large and complex litigation matters. We have insurance companies literally involved in hundreds of millions, if not billions of dollars of claims. With this massive, complex, multi-state litigation comes the desire for lower cost, efficiency, and continuity.
Well, Clark, let me ask you a question.
Yes, sir.
If you say it's lower cost, but it appears to me you're shifting the burden to the other side in many cases.
Mr.
So
Chairman?
you're paying $1,000 for your side, and you're making the guy on the other side pay $4,000.
With the greatest respect, Mr. Chairman, that was one story. And I would assert if my clients could be here today and if they could conduct a study with the Virginia Bar Association, they would tell you that they are fully supportive of comparative pricing that is in this bill. They are fully supportive of transparency, which is in this bill. But they are not fully supportive of the General Assembly of the Commonwealth of Virginia telling them by law that they no longer can conduct business in the Commonwealth of Virginia by limiting their transactions to one matter. That's the heart of this bill.
And you're referring to a contract?
I'm turning that if we have a multi-case transaction with a third-party administrator or insurance companies, we may have 50, 100 of them going right now. If this bill is enacted as of July 1st, those contracts will end.
Explain to me, just give me 1 second. Help me with this.
I believe Senator Obenshain is nodding in agreement.
Because this really bothers me. And it bothers me a great deal because I'm an officer of the court as a law practicing attorney. How does a court reporter who is engaged in a contract with one of the parties in the litigation not have a conflict of interest when they are reporting that matter for two parties?
Mr. Chairman, members of the committee, first of all, let's step back. The concern is that the conflict will cause the court reporter to do something.
Answer that.
Yes, sir.
Step in, but just answer that question for me. How do you not have a conflict of interest?
They pay the bills the way it is today. The insurance defense lawyer hires them and sends the bill to the insurance company. That's the way it is now. That's exactly the way it is. It's just a step in between. If I'm an attorney at Troutman Sanders, I hire a court reporter. The court reporter bills me. I send the bill to the insurance company. That's the way it is right now. That's the practice. All Senator Obenshain's bill does is make me the decision maker of who I'm going to ask as to be a court reporter. I'm still sending the bill to the insurance company.
Doesn't help me. Senator Reeves.
Would you be a little more receptive if we took out lines 36 through 40 of the substitute?
I think that and some other provision is the heart of our objection, which limits our ability to transact business in Virginia. Mr. Chairman, yes, sir, to answer your question. And I haven't mentioned the penalty provision in this, which if you are found responsible, you could have a $500, $750, or $1,000 fee, but the court can order that the court reporting service be banned from that jurisdiction and banned from conducting business in the Commonwealth of Virginia. There's no due process set out. There's no appeal provision. There's no time limit that you could be banned. There's no process for you to determine how you can get back into Virginia and conduct business again. Likewise, the bill, interestingly, exempts local governments and the state of Virginia from doing what the bill seeks to ban. The state can continue to do it. Local governments can continue to do it. And, Mr. Chairman, it specifically on line 58 says that you can no longer offer trial advocacy litigation support services, which includes deposition summaries. I think most of the court reporters in here offer those services. They would be banned under this bill. Mr. Chairman, with respect, we believe that there is an opportunity for greater transparency. We think there's an opportunity for comparative pricing. We would respectfully and appreciate the senator bringing this issue to our attention, and we would be honored to work with the Virginia Bar to study this issue further. But we plead with you not to make this decision that would end the great majority of our contracts on July 1st, 2018. Thank you.
Thank you. Anyone else in opposition? If not, Senator Obenshain, you want to?
Mr. Chairman, what you've heard is that there are a couple of large national companies that have rolled up most of the court reporting business, or a lot of the court reporting business, for some of these large institutional defendants in cases. And their practices, if members of this committee haven't experienced them, they need only make a couple of phone calls in order to figure out the impact that this has on litigation and on parties. It's wrong. They should not be contracting with insurance companies for the provision of court reporting services. They need to be officers of the court, not officers of a defendant or a plaintiff in pending litigation. And this restores that relationship, which is, quite frankly, absolutely necessary to the integrity of our system.
Okay. Are there any other questions of the patron?
Yes, Mr.
Senator
Chairman. And Senator Obenshain, I understand what you're doing, and I agree 100% with the comparable costs and all that. But if they contract with an insurance company, so pick an insurance company, contracts with one of these nationwide companies, they are not then contract with the party who's had a car wreck. There's a difference between an insurance company, a law firm, and the person in the car wreck. I have serious problems with lines 36 through 40. The rest, insurance company is not a party to a lawsuit in a car wreck.
They are a party in interest. And I understand. And I understand that's the heart of the opposition, but that's also the heart of the bill.
Senator Sturtevant.
Mr. Chairman, Senator Obenshain, but it would, to Senator Peake's question, it would not prevent a law firm from entering into an agreement for a court reporter or court reporting firm to cover multiple cases.
Sure.
Provided that the same deal that is offered to that law
Absolutely.
firm is provided the other side.
Absolutely.
Any other questions of the patron? If not, is there a motion?
I move the report, the substitute.
There's a motion properly seconded to report the substitute. Clerk, please open the roll.
Ayes 14, noes 1.
All right, Mr. Chairman, members of the committee, thank you very much.
Okay. Senator Searle, you have some bills before the committee?
Too quick.
What would you like to start with?
My book is open to 609. Why don't we start with that?
609.
Senate Bill 609 is just to clarify existing law for those of you who don't go to juvenile court very much. Juvenile court judges are afforded really broad jurisdiction to continue charges for dismissal or to reduce convictions after somebody's been convicted after a period of time if somebody's had good behavior. Some practitioners in Loudoun County brought to my attention that a Loudoun County juvenile court judge believes that in light of the Stars, Taylor, and White decisions, they no longer have that discretion. The Stars, Taylor, and White decisions have to deal with adults, not juveniles, but for some reason that court thinks that those cases limit her authority, and therefore I put in this bill just to clarify that juvenile court judges, notwithstanding Stars, White, and Taylor, still have the authority to render SIS's continued charges for dismissal and findings of guilt or reduce felonies to misdemeanors or after a period of time for good behavior. That's all the bill does.
Senator Searle, is there really any question as to whether or not they already have this jurisdiction?
Most other lawyers I talk to don't believe so, but I don't like calling up judges and telling them they're deciding cases incorrectly. It puts me in kind of a weird position, even though this judge isn't in one of the circuits where I vote. Still, I have to practice in front of these people, and as a senator, it's kind of uncomfortable calling up and telling them that they're completely wrong on something like that. But it is affecting the children that appear in front of this judge who are not being afforded the same remedies that other children in the rest of the state have. So it's something I think needs to be corrected.
Any questions of the patron on this bill?
Mr. Chairman.
Senator Peake.
Senator Sorrell, so you're saying there's one judge you're aware of who's not following the law? And so we've got this statute to codify what is the known law?
To make it clear what the law is, but yeah, and I put out I'm on a listserv. I put out a request last night to ask if anybody else knew of any other judges that were finding similarly after the Taylor case, which came down, I think, about 4 or 5 months ago. And, nobody has responded to me, so I'm not aware of any other judges, but
Mr.
it
Chair,
might be.
Mr. Chair, I'd say to Senator Peake, that's 40% of the bills down here.
Yes.
There used to be a time, Mr.
Senator
Chair.
Deeds.
It used to be a time, Mr. Chair, when when the committee of the chairman of the committee would just write a letter, write the judge a strong letter, and that would end the matter.
Right. Well, if the chairman would like to write this judge a strong letter, I'd be happy to draft it.
Depends on who it is.
I guess my question, Senator Searle, would be, would we be limiting the jurisdiction of the court in any way by including
this language?
No. And I don't know the answer to that, but right now it's pretty broad.
No, because this just says that the authority includes the following, but I don't think that limits it in any way.
That is my concern.
Right.
All right, anybody else have questions of the patron on this? Anybody want to speak on behalf of this, for it, support? Anybody want to speak in opposition?
I checked with the Commonwealth attorneys. They didn't have a position on it.
Okay.
Mr. Chairman.
Mr. Benjamin.
I should advise the committee that there is a problem in that it's not limited to juvenile and domestic relations courts. There have been many decisions on the power of the judiciary to continue a case for the purposes of dismissal. And the most recent case was a Court of Appeals case that, in summary, noted that the law is anything but clear as to the powers of a judge. And this is juvenile and this is all courts. I don't know if this bill is a solution. It may be a partial solution, but I should tell you that there are some courts that believe that the current state of the law is that they cannot permit a continuance of a case if the purpose of the continuance is to place somebody upon terms and conditions and then dismiss the case. By terms and conditions, what I mean is that, say, a common scenario is a first offense shoplifting. And the parties, the Commonwealth and the defense, agree that if the defendant goes to a shoplifting prevention class and is on good behavior for 12 months, then the case should be dismissed. There are courts who, because of the uncertainty of the case law, believe that they cannot be a party to that, and they are no longer permitting that practice. So I can tell you that there is a big problem, and this may be a partial solution. I don't know.
Well, Mr. Benjamin, I understand exactly what you're talking about. Does this really go to the provisions of a court issuing an advisement on a case? I'm not sure it does.
I don't know that this is in the appropriate form. I just don't know that.
If that's what I don't think that's what the patron's trying to do. I think he's trying to clarify that the juvenile court retains jurisdiction over the case of a juvenile until he's 21. Of a person.
And that, Mr. Chairman, may or may not already be the law. If the judgment is final, then Rule 1:1 still prevails, and the court loses jurisdiction after 21 days in that particular case. But if the court has continued the case for purposes of further measures, then the court, under existing law, does retain jurisdiction.
Mr. Chairman?
Senator Peake.
Mr. Benjamin or Mr. Thorold, is that the purpose of your bill here, is that you have a particular judge who is not following what Mr. Benjamin just said?
First of all, make clear, it wasn't my case. And, you know, this is, other lawyers have called me up and said, have explained this to me, that this, at least one, maybe both, I don't know, of the juvenile court judges in Loudoun don't believe that they can continue a case on terms and conditions for dismissal, or they also, there are situations in juvenile court where a judge can convict of a felony, then after a period of time, 6 months, a year or two, if the child's been good, they can reduce it to misdemeanor. And that's something that historically, for 21 years I've been practicing law, everybody's done in this state because of this statute. But because of this White opinion, which came down from the Court of Appeals on May 2, 2017, some judges think they no longer have the authority to do that, even in juvenile court. I think for adults, my bill has nothing to do with adults. I don't even want to get into that mess. This only has to do with juveniles.
Senator Obenshain.
Mr. Chairman, I move to report.
Is there a second? Second. There's a motion properly seconded to report the bill. Clerk, please open the roll. All right.
Ayes 14, no zero.
Mr. Chairman, before the bill leaves the committee, my question for the senator is whether his intent in introducing the bill would be more fully met if he included the word dismiss, so that the court retains the power to suspend, reduce, modify, or dismiss.
Yes, it would.
I move that amendment.
Well, we're going to have to
unwind it.
Move to reconsider the vote.
Reconsider.
Is there a second? Motion properly seconded to reconsider the vote by which we reported Senate Bill 609. All in favor, please say aye. Aye. Opposed, no.
Move the
Could you
amendment.
report that amendment again, Mr. Benjamin? Add the word "or dismiss."
Yes, Mr. Chairman, line 14, after the, strike the first "or," after the word modify, excuse me, comma, or dismiss.
Or dismiss. Is there a second to that motion?
Second.
Motion properly seconded to amend the bill as reported. All in favor, please say aye. Aye. Opposed, no. The ayes have it.
Move the report as amended.
Motion properly seconded to report the bill. Clerk, please open the roll. Still report. All right, turn it back over to the chair.
All right, next, I don't know whether you're going to have the same luck with this one, but 628.
Thank you, Mr. Chairman. So 628 says that it basically says you cannot be a notary public if you've been convicted of a misdemeanor of moral turpitude. That means lying, cheating, or stealing, unless you've received a simple pardon from the governor for those offenses.
All right, Steve, is there a definition in the code of moral turpitude, misdemeanor involving?
Mr. Chairman, there is not a definition in the code of crimes involving moral turpitude. However, that phrase is used throughout the code. it would be better to specify the crimes. I don't know if the patron is in a position to amend the bill to the crimes that he, let me put it this way. I don't know what constitutes crimes against moral turpitude, although apparently it's settled somewhere.
So you want, I mean, if somebody applies to be a notary public, is there a time limit?
Mr. Chairman, that's a good point. What I would suggest, consistent with this committee's practice, is after the word turpitude on line 16, insert the words committed after July 1, 2018. So that,
Okay.
and what that, the effect there would be that if anyone commits a crime of moral turpitude after the effective date of the bill, then they would be prohibited from being a notary.
Forever?
Unless they receive a simple pardon from the governor, that's already in the statute.
So unless they receive a simple pardon, they're prohibited forever. So somebody shoplifting,
Or their rights restored.
or their rights
Well,
restored?
that's already the case for a felon. So right now, a felon can have their notary rights restored as soon as their voting rights are restored.
That's current law.
So this would just say if it's a misdemeanor, you have to get a simple pardon.
All right, Senator Stewart.
Senator Servo, would this include a kid that had a bad check, 16-year-old trying to establish his credit and he was convicted of a bad check offense? Or even convicted of shoplifting when they were a juvenile?
That's not a conviction, that's an adjudication of delinquency.
Under a juvenile would not be affected by this.
Right.
Senator Peterson.
Yeah, just practically, because, you know, my staff goes in and gets notary determinations. If you're going to have an application, are you now going to require them to list out all their misdemeanors and decide how is a layperson coming into the courthouse to fill out this application going to know what's a crime or what's a misdemeanor of moral turpitude? Everyone knows what a felony is.
Right, well, my assumption would be that the Secretary of the Commonwealth would promulgate some clarity on that of a list of offenses like they have for similar things, and perhaps they'd have language on the form that would say, I assume it's like a checkbox, not having to list out offenses, but probably a checkbox where you have to certify you've not been convicted of a felony or a misdemeanor involving lying, cheating, or stealing.
Further question, and this would
Senator
include
Peterson.
juvenile adjudications?
No, that's what I just answered Senator Stewart, is that juvenile adjudications are adjudications of delinquency. They're not convictions under the code. That's the term of art we use in the code to differentiate the two.
Mr. Chairman,
Senator
you
Edwards.
say it's easy to get a simple pardon. It's not easy to get a simple pardon. It's extremely difficult to get a simple pardon. You may be referring to restoration of rights.
Yeah, I didn't say it was easy to get a simple pardon. I was talking about restoration of rights, which our last governor, I think our current governor, has simplified that process.
Mr. Chairman, that's different.
Senator Edwards.
Mr. Chairman, that's very different than wiping off a misdemeanor for moral turpitude or a felony from your record. I mean, that doesn't do that. It just gives you the right to vote and other
Says
civil
or
rights.
has had his rights restored.
Sorry?
It says or has had his rights restored.
Right.
So either one.
Right.
All right.
Where does it say that?
And I can also,
Senator Deeds.
I always thought crimes of moral turpitude involve lying, stealing, and cheating.
Right.
Maybe you can't define them specifically, but you know in general what they are. But in order for the Secretary of the Commonwealth to do what you want, aren't you going to have to define more crimes of moral turpitude in this statute?
I don't think so. I think we could maybe add an enactment clause, just asking the Secretary of the Commonwealth to publish a list of offenses that they would say qualify as crimes of moral turpitude. That might, I think, resolve the issue.
Mr. Chairman.
Have an enactment clause
All
on
right,
there.
Senator Edwards,
Yeah,
we
but
have to roll here.
another thing-
I mean, if you don't like the bill, let's.
Nobody goes
Can
to
I-
get their rights restored because they got a petty larceny conviction. They don't do that. You can still vote. And I don't know how in the world you would, the Secretary of the Commonwealth who gives these notary seal, authorizes people to be notaries, is ever going to know this. Hey,
All right.
Can I ask you?
Isn't that
Mr. Chairman?
right?
Yeah.
Yeah.
What gives rise to this bill?
What gives rise to this bill is a Fairfax County Circuit Court judge I was talking to had a situation where a woman who was a notary public conspired with a friend of hers to file basically a falsified mechanics lien on a trailer, which resulted in eviction of a person from that trailer. The notary had already been convicted of identity theft, petty larceny, filing a false police report, receiving stolen property, and larceny by false pretenses, 6 misdemeanor theft convictions. And he was shocked that somebody with a record like that could become a notary public and be certifying to the validity of signatures and the truth of what people say in legal documents. And he suggested that ought to be not allowed.
All right, anybody from the audience wish to speak in favor of or in opposition to the bill? The bill is before us.
I have a
Let's
question
make
to
them.
counsel or somebody. If a notary does these things, is there a process to denotarize them? Charged with something else? I don't know. How do you get your notary seal taken away from you if you've committed these kinds of offenses? That would be a process.
All right, there's a motion to report the bill. Is there a second?
That's not working.
All right, it's been seconded. Any further discussion? Clerk will open the roll.
Ayes 2, noes 13.
All right, thank you very much.
Thank you.
All right, next, Senator Cosgrove. Sorry to keep you waiting so long.
Good morning, sir. How are you?
Is it still morning?
Yeah, just barely.
7:98.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate your information over the weekend on this bill.
Yeah.
Mr. Chairman, it's Senate Bill 798. And this bill authorizes the court to provide a copy of pre-sentence report to the director or administrator of a work release program if the person who is subject to the report is under consideration for participation in that program. Mr. Chairman, your information basically has some very good points in it about the sensitivity of the information contained therein. So I'm wondering if an amendment could be made on line 49 after report period, insert with the consent of the defendant, comma.
Steve, are you listening to this?
If I may repeat, sir. On line 49, after person subject to the report period, insert with the consent of the defendant, comma.
And, John, I appreciate that. This bill, just to refresh the committee's recollection, and I go through this with no hostile intent, but this bill was before us last year. Delegate Leftwich brought it. It failed to report, or was passed by indefinitely on a 12-3 vote.
Right.
Senator McDougal and Senator Norment in particular had grave concerns about confidentiality of these pre-sentence reports. My recollection was that these reports are carefully guarded. The current statute prevents them from being shared, and this opens it up, and I appreciate the suggestion about with the consent, but I'm not sure that all of these folks understand the impact of that consent. Steve, do you have any thoughts about this?
Mr. Chairman, my thoughts echo the concerns the chairman has indicated. Pre-sentence reports are intended to be and are meant to be confidential in order to encourage the sharing and the provision of sensitive and often private information to the sentencing court. The practice over the years has been to preserve this confidentiality with several few exceptions that have been created. But this committee has always been careful about ensuring that pre-sentence reports remain confidential so that the necessary information can be provided to the sentencing judge.
And are jails typically provided with that information or not?
No. They are not.
They are not.
Okay. Department of Corrections?
They are.
Well, Mr. Chairman, I guess therein lies the rub. If the Department of Corrections is able to receive this information, I don't see why the local work release program, basically that's a benefit to the defendant, wouldn't get this information to expedite their inclusion into the work release program. And that's the bill, Mr. Chairman.
Okay. Anybody have any questions of the patron?
Mr. Chairman.
Anybody wish to, John?
Before you get work release, the sheriff has to approve it, or the Department of Corrections has to approve it. Isn't that right?
In the local, Mr. Chairman, in the local level, the sheriff who's
Sheriff,
operating the jail has to agree to it, yes.
Okay. Anybody in the audience wish to speak in favor of or in opposition to this bill? All right, the bill is before us.
Move to PBI.
All right, there's a motion. Is there a second?
Second.
To pass the bill by indefinitely? All right, motion been made, properly seconded to pass the bill by indefinitely. Clerk will open the roll.
I'm an engineer, I can count. Thank you, Mr. Chairman. I appreciate it. Thank you for your help.
All right, thank you. All right. Who do we have next? Senator Vogel. Senator Vogel.
Thank you, Mr. Chair. I have Senate Bill 899, and before I explain the bill, I have a substitute.
I'll move the substitute.
And once the substitute is before you, I have.
All right, the substitute's been moved and seconded. All in favor of adopting the substitute, signify by saying aye. All opposed, substitute's before us.
This substitute was created yesterday, late in the day.
I understand.
Yes, and there is, as I was looking at this, I know of one thing that has to be changed. And this is something that we had gone back and forth when we were working with the Attorney General's office. And there were some edits that we had made in a previous draft of a totally different bill. But in this bill, I can tell you that on line 14, after the word governor, we need to insert or his designee. Not even being staff at the AG's office, I know that. So I'm going to ask that we please insert that language.
After governor, before in writing, or his designee?
Or his designee.
All right, it's been moved and seconded. All in favor of that amendment, signify by saying aye. All opposed, that amendment is adopted.
Now we have this fine bill in front of you, and I'm going to make an effort to explain why you have it.
All right, now, I mean, this is a conveyance bill. The other conveyance bills went through.
It's not a conveyance bill anymore.
I know.
It's a little different now.
Yeah, okay, go ahead.
It's a hold it up bill. Okay. So what we had was back in 2014, 15, that range, a number of folks in the addiction and recovery community, as well as all of the representatives of public safety in Winchester, Frederick, and Clark County, came to me and said, we have been looking diligently for a location where we could have a campus, where we could have an addiction treatment and recovery facility. And they wanted to know what I could do to help. One of the biggest issues that they had was that there was this corrections facility, Camp 7, that was no longer in use. It was surplus property that had been converted by the Department of Corrections into nothing, and now was being held by DGS. And so I set about on an odyssey that ended up as a complete failure to try to get the property conveyed to Clark County. And for a number of reasons, the Finance Committee didn't want to make that conveyance in language in the budget, and that didn't go anywhere. But in the meantime, the communities there have continued to work hard to try to create an environment where they could have access to some portion of that property. It has continued to remain unused, and the Clark County community, as well as Frederick and Winchester, have continued unsuccessfully to try to find a location for a campus. So as they've had ongoing discussions, I have come back this year after Clark County, working with the administration, the Department of General Services. They are prepared to move forward. They are prepared to commit to purchase, not any longer now the entire property, but a portion of that property, now a 65-acre portion of that property at fair market value. They got a letter recently from the Department of General Services back in the summer, making them aware that the property was still there and as yet unencumbered and not sold, offering them the opportunity. And they said yes. Their concern is they don't have the financing. Yeah.
Jill, I mean, here's the problem, at least as I see it with this, is you say fair market value. There's no assurance in here that it's going to be fair market value. We're delegating our authority to approve this sale to the governor without any assurance as to what the price is. I mean, typically, we, we say grace over these pretty automatically, and I understand this has been held up, but, traditionally, we've been very reticent about making that kind of delegation on faith, and that's a challenge.
Well, where I started was I wanted the conveyance at something less than fair market value. And obviously, that doesn't fly. Where we are now is that what I'm asking is that for the legislature to agree to allow the Department of General Services not to convey the property until July 1st of 2019, to give Clark County the option to come in and negotiate with the Department of General Services for the purchase of the property. That's all we're asking now. We have backed way up from where we were initially, which was hoping for just a transfer of surplus property. The original language was an authorization bill that would have allowed the governor the discretion and the authority to make such a transfer at less than fair market value. We're not there anymore. Now we're just asking for the property to be held so that they have a shot. That's all they want now, just a shot.
Kristen?
Mr. Chairman, if that is the patron's intent, I'm not sure that this substitute achieves that. It says on lines 13 and 14 that any dispositions of Clark County shall be agreed to by the governor or his designee in writing, and the attorney general as to form. And then on lines 17 and 18, it just says that the conveyance cannot be to anybody else other than Clark County before July 1, 2019. So my interpretation of this language is that up until July 1, 2019, the General Assembly, would be allowing DGS to enter into these negotiations for the purpose of conveying the property, which they can't do with anybody else but Clark County until July 1, 2019.
Right, we're trying to give them the option, basically the option of getting the first shot at it.
Yes, Mr. Chairman and Senator Vogel, but the language would allow that conveyance to happen before July 1, 2019. So it's not just holding it up. It would be
At any time prior.
Right, that's the idea is to give them the opportunity
Jill,
between now and 2019.
This is a massive deviation from what we have always adhered to in order to make sure that the interests of the Commonwealth are protected, and a delegation of that authority blindly. And I mean, I'm not trying to single this out, and I know that you've worked hard and that there's,
right.
a good purpose. I mean,
Well,
it's up to the committee, but
well, here's what I would just
quite uneasy.
tell you, Mr. Chair and members of the committee. I am without any other option to try to do the best I can for the constituency that I represent, the people in public safety, the addiction recovery community, and frankly, Clark County, that has such a great interest in seeing this property not just sit there and also, not go to a use that they think is actually in the best interest of the community. And I regret that the member of the Board of Supervisors, who's been the great leader on this, isn't here this morning, but he, in a note that he sent to me said, the establishment of an inpatient drug treatment facility at this location remains the county's highest and most immediate priority and interest. And he goes on to talk about the other value in that property. So all I'm trying to do is figure out a way that Clark County has an opportunity, having worked through this with DGS, and they are going to give a portion of it to VDOT. They've got another use for the Department of Military Affairs. And so Clark County just wants a shot. And they're no longer looking at the whole piece anymore. That's not even in play. Now they're looking at just a little corner of what used to be a correctional facility to use for this purpose. That's what we're looking at. And we're just asking now that they have the option, for lack of a better explanation, the sort of right of first refusal, so that they can be in this negotiating process and have a shot before they lose it.
Well, why don't we simply say the property shall not be disposed of or sold prior to next year, so you can come back with a conveyance bill.
I had a conveyance bill, but that didn't work.
Well, but because there's no agreement.
I've tried it all.
I mean, we can't
Right.
we can't
That's
force
true.
feed
That's true.
a conveyance.
Okay, I am at the mercy of
How
this.
about if
Clark
we-
County and I are at the mercy of this committee, and the folks who've been working on this forever. I feel quite guilty and sorry that we haven't made more headway. They are very anxious not to lose their opportunity and very anxious not to see that corner of a really important piece of property go to something that's not in their minds.
Does the state not, I guess the state doesn't share the view about the importance of this.
The Department of General Services is,
So can we carry this over?
I'm at the will of this committee.
Yeah, I know, but.
No, I don't want you to carry it over. I'd like you to pass it so that Clark County gets this shot.
Move to report.
Would you like to hear from DGS, Mr. Chair?
It has to go to finance.
I was afraid of that. I knew that was where this was headed.
There's a motion to report and re-refer to finance. All right, clerk will open the roll.
Ayes 10, noes 5.
Thank you, Mr. Chair and members of the committee.
Yes, ma'am. All right, next bill. Do we have any other patrons here? I'm sorry, Senator Stewart, you ready?
Mr. Chairman, on Senate Bill 308, Mr. Benjamin, I will tell you, worked with the Commonwealth's attorneys. I've used the language that actually the gentleman from Waynesboro suggested, but I still can't get a bill that the Commonwealth's attorneys like, even though I've tried. So, Mr. Benjamin, we've changed that to, well, would you report that, Mr. Benjamin, first, the amendment?
Yes, Mr. Chairman. First, note that in that bill, the new language in the bill as it exists, I don't have it in front of me, but would be struck, and then the bill would be amended. The bill would be amended to put at the end of each of the two lines that I gave you before the following language. This section shall not apply to any person driving or operating a motor vehicle on his own residential property or the curtilage thereof.
All right.
Second.
That amendment's been moved and seconded. All in favor of adopting that amendment signify by saying aye.
Aye.
All opposed. All right, amendments before us.
So, Mr. Chairman, where I think we are now is that is basically your home and your yard. It may extend out a little bit farther than your yard, and could be considered as that. But in speaking with the Commonwealth's attorneys, and God bless them, they do a great job, but they can come up with a million scenarios as to why we should prosecute a farmer on their tractor drinking or something. So
what the Commonwealth's attorneys are saying is let us exercise our discretion and good judgment.
And a lot of times they do, but you've got some youngsters that don't. And so this is to protect the
And that's
people
why
of
we have
Virginia
good
from
attorneys
from
like
the
you to
youngsters.
represent. All right. Let's let the Commonwealth's attorneys real briefly.
Mr. Chairman,
You don't
David
like
Ledbetter, Commonwealth's attorney from Waynesboro on behalf of the association. We understand where the senator's trying to go. I was the one that gave him the idea. It gives an out for the guy sitting in the car playing his radio, but it also gives outs for other people. We don't want to give an out for a guy, for instance, operating an ATV drunk that kills a kid. We don't want to out him from not only DUI, but DUI manslaughter. So in trying to protect the guy that's in his car listening to the radio, the language extends out and exempts people we don't want to exempt. And so that's where we're coming up with, is the problem with the language, trying to get the right language.
Senator Stewart.
I mean, couldn't you already prosecute that other person without including DUI?
For manslaughter?
Well, if it's not his own child, you can't get him for child abuse or neglect, because that'd have to be a local parentis for child abuse and neglect. If it's the neighbor kid, you're not there. So that's the problem with that, is that by having him where we can't do another DUI very limits our remedies for them. And while the people we're trying to protect, who you want to protect, where that does protect them, it goes to others that we don't want to protect. And that's that's our problem is.
Mr. Chairman.
Senator Peake.
So if he's driving an ATV on his private property, there's no implied consent, correct?
That's right.
So you're just going by his activities. Wouldn't it be the same under manslaughter?
But if you exempt him from the DU.
But still reckless, gross negligence, and you go into all that conduct to get him under manslaughter, same as you would DUI manslaughter because you wouldn't have the presumption.
We wouldn't get an implied consent, but I think we could still, if there was evidence of his blood alcohol levels and things, if we could gather that evidence somehow, for instance, he goes to the hospital because he injures himself, and we get the evidence from the hospital, or
That
through a
would still
search
be
warrant.
admissible in a manslaughter prosecution without a DUI. Mr. Chairman.
And that is possible, but the other thing, I'm just thinking of that one example. I'm sure my other Commonwealth attorneys can think of other examples where it's caught. That's why we vet them, and we take a lot of time with this and vet it past a bunch of Commonwealth attorneys, so we catch it in the different scenarios. And trying to do it fairly quickly this morning, I'm not sure, I'm afraid we're going to exempt somebody we should not.
All right. All right. Bills before us, there's been a motion to report. I'm sorry, Charles?
Just so I'm clear, Mr. Chairman, the amendment is to restore 18.266 and 18.266.1 to its original language and then insert at the end of it the language that Steve suggested.
That's correct, Mr. Chairman.
Thank you, Mr. Chairman.
All right, motion is to report. The substitute is amended. Clerk will open the roll.
Ayes 14, noes 1.
All right, congratulations. All right, and Senator Peterson, you have peace on your bill? I don't think you do.
I don't think I do either.
Let's say.
But I'd rather have justice than peace.
All right, let's do this quickly. This
Yes,
is.
sir. I have a substitute to distribute. This is Senate Bill 224. And this is what I call the reverse forfeiture bill. It deals with situations
Senator Peterson moves. Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. All opposed. The substitute's before us.
It deals with situations where the Commonwealth has lawfully seized property, but then decide not to bring a criminal charge, and for whatever reason, don't want to return the property. And so this bill kind of rode into town on a Harley and it's leaving town on a moped because the way I originally had it written, the Commonwealth had an obligation after a year that they would have to find the property owner and give the money and give the property back. This now puts it in the obligation on the property owner. They would actually have to file a petition after 1 year in which they would then come forward and there would be an in-camera proceeding in which the court would have to make a determination as to whether or not there is a pending criminal investigation in which this property was relevant.
All right.
Let me make one amendment, Mr. Chair, to get this completely in the position it needs to be in. If I could, on line 19, where it says, or under any other provision of this code, strike that language and add an insert, or Title 19.2 of this code, or under Title 19.2 of this code. I'll move that amendment if I can get a second. Thank you.
All right, the amendment's been moved and seconded. All in favor signify by saying aye.
Aye.
All opposed. Amendment's before us.
And the purpose of that amendment is to make it clear that we're talking about property that's seized in a criminal context. It's not none to do with condemnation, civil, nothing. This is criminal proceedings and investigations.
Let's hear what the Commonwealth's attorneys have to say about this.
I did too.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth's Attorneys, and we appreciate the patron listening to our concerns. And we've reached an agreement in concept that there is still some concern about some of the unanswered questions of this particular language. And while this bill amends a section of the asset forfeiture proceedings, this really does not have any connection to asset forfeiture because an item that is seized for asset forfeiture is the Commonwealth Attorney must file an information within 90 days under existing law. If they do not file an information within 90 days, we must return the property. So this is not dealing with asset forfeiture. This is dealing with evidence of crimes. And while we appreciate the line amendment that has been made limiting this to 19.2, there's still a question as to what happens if the property is seized pursuant to a warrantless seizure, something that is an exception to the search warrant requirement, and it is not done under Title 19.2. What happens to that particular evidence? Another significant issue is what's the procedure for this particular petition? In which court is this petition to be filed? Is it to be filed in circuit court? Is it to be filed in general district court? Is there a sealing provision for this petition? How does the court know that the person is actually an owner? Under asset forfeiture, they have to allege under oath that they are the owner, but there's no requirement here. Do the rules of evidence apply during this hearing? Or is hearsay admissible? Is there a right of appeal? Who gets the right of appeal? Is there discovery available during this particular? And if this is a civil action, is this discovery it goes in both directions, where we can depose the petitioner, where we can ask for interrogatories of that particular petitioner as they can of us. There are a lot of questions. I'm not saying they're insurmountable. They're just the questions that we need to have more time to deal with, and we just have not had the time to deal with that.
So you'd like a year to deal with them?
We would like, yes, we would, please.
Okay. Now, anybody have any questions? All right, we've heard this bill, we've heard the amendment, it's before us. You want to move to report?
I'm going to move to, can I just make one?
Or something else?
Well, I'll move to report, but if I can make one response. All right, I'll move to report.
All right, motion reports before us.
Substitute motion,
All right, substitute motion.
that it be carried over for a year.
All right.
Can I speak to that motion?
Is there a second to that motion to carry it over for the year? I would if I could.
Don't.
All right, there's no second to the motion, so it needs to go to the Committee on Finance. It's been requested.
Why?
Why?
I don't know.
You know, I don't think they have the, well.
Look, I've lost that fight for years, so, you know, you want to fight it?
No, I'll just,
Okay.
there's other ways to fight it.
All right. Motion is to report and re-refer to the Committee on Finance. Crud.
Ayes 12, noes 3.
All right. Your next bill, Senate Bill 142.
Yes, the next bill actually is a little bit of an, it's a
let me set the table for
Sure.
this. This bill is identical to a bill introduced in the House last year by Delegate Gilbert, passed out of the Courts Committee, but was defeated on the floor on a close vote, 45-49 and 1. And the bill deals with failure to appear, essentially being a waiver of your right to appear, on failure to appear on a criminal appeal from General District to Circuit Court. And under this bill, if you fail to appear, presumption is it was willful and you meant to abandon your appeal.
Right.
Okay?
I think you stated it perfectly. I don't need to add to it.
Steve, concerns? Do we want to impose that presumption on somebody who may have forgotten, was ill?
That is a policy question, Mr. Chairman. People miss courts for a variety of reasons. Sometimes it's willful, they just decide they don't want to go. Other times it's because they've been incarcerated on a new charge and they can't appear. They might be ill or they've mixed up the dates. I've had clients before be given the wrong date by a well-intentioned deputy who just got it wrong. And so there's a variety of reasons, some willful, some not willful. And what the bill does, and again, this is a policy question, is shift the burden to the defendant to prove that it was not willful.
All right, Mr. Chair, can I respond to that?
Yes.
There's a savings clause on lines 38 through 42, which talks within 60 days of the order affirming guilt, that the person could come back into court if, for example, they had been out of town, or I don't know why, if you had been convicted of a crime, you would choose to leave town, unless you were not wanting to show up in court. But if they actually had a legitimate excuse, they have a 60-day savings clause. That's in the bill.
Okay. Any questions of the patron on this? Is anyone who'd like to speak for or against this?
Mr. Chairman.
Yes, sir.
So I'm
Senator McDougal.
just trying to understand what you're trying to do. If for this to occur, somebody has to be found guilty of a misdemeanor or a traffic offense, correct?
In general district court.
That's all we're talking about.
And
Or
they notice
juvenile and
appeal.
domestic
Right.
relations.
And they notice appeal and then they don't post.
They notice appeal and don't come. If the court wants to, if the person did not receive active or suspended jail time, then the court just can try them in their absence and move on today, correct?
Well, my understanding is they can't try in the absence. In other words, there's just no disposition.
Mr. Chair, why could a court not try you in your absence if there was a notice of appeal that you or your attorney signed and you didn't show up, and if there was a waiver of jail time or offense for which you could not receive jail time, why can't they just try you in your absence?
Okay. And Senator McDougal, I'm more on your territory than my territory here, but my understanding is they do, if they notice the appeal and then they leave the jurisdiction and are no longer within the jurisdiction of the court, then you can't have that trial. Now, maybe that's the distinction about not having jail time or having jail time.
Mr. Chairman?
Senator McDougal.
That would, if that was the case, then that would be the same thing if somebody was out of state and had reckless driving through Virginia and they kept on going and didn't stay here, we'd never be able to prosecute or proceed on any of those cases. So that doesn't, I don't see how that's not possible. So I guess, Mr. Chairman, my question is,
Senator McDougal.
then if there's active jail time that's being sought, court can issue a capias for the person to come, and if not, why aren't they just being tried in their absence and penalty given, which could include a fine or license suspension? It could not include suspended jail time. What's the problem with fixing?
All right, I'm gonna phone a friend here.
Okay.
Yes, sir.
Mr. Chairman, David Ledbetter, Commonwealth's
best
Attorney
friend.
of Waynesboro. We support the bill. The situation that the senator describes, where we could try somebody's absence, we can do that on a traffic, but anything that's jail time, if that person doesn't show up, we've got our witnesses there, the Commonwealth's ready to go. We have to either issue a capias, bring everybody back again, and have to wait, and that person is often held on the capias till brought back
But
before
you
the
do
court.
issue a capias and have that person
My
picked
circuit
up.
court does issue a capias.
Right.
I think this is a much more clean procedure because the person has notice of it. They've signed the recognizance bond saying to be there, and there is the option, if it's just an absent-minded, that the judge can reopen at that. But it
Mr.
puts the
Chairman.
burden on the defendant versus putting the burden on the Commonwealth to continue.
Senator McDougal.
Mr. Chairman, these cases are trial de novo, so I do not see why we would have any different practice in district court that we have in circuit court. It's just like it started again. So if the remedy is in district court, that if somebody shows and y'all, being the government, makes the decision that you want to seek active jail time, then you issue a capias for them in district court. If you don't care about jail time, then you waive jail time, and the court hears the case with the witnesses you have. Why would we do the procedure differently under a constitutional trial de novo right in circuit court than in district court?
Mr. Chairman, if I may, I think the issue is this is a failure to appear is a significant problem on misdemeanor appeals day. A typical misdemeanor appeals day, I'll probably have, say if I got 10 cases, I'll have 2, if not 3, that do not appear, and that's taking up the circuit court time, and I think that's the issue, is where you're trying for the efficiency, and I understand it's a de novo situation, but I think that's where the thrust of the bill is behind. I understand that it's.
Well, it takes you all of the time that it takes to call the case up. The defendant is not there, and you say, judge asks capias be issued. And judge says, clerk issue a capias. So it takes about a minute.
It may be on court time, but it's also all those witnesses that have had to be resummoned and reappear.
Mr. Chairman.
Senator McDougal.
I can't see how your constitutional right for trial de novo changes when you're in circuit court, which should be more protective and more certainly on the record conversational about those rights than it is in district court, than it's where it is, you don't have that same right to a jury or other things. So I would gently move to PBI.
Is there a second to that? Motion properly seconded to pass the bill by indefinitely. Clerk, please open the roll.
That's all right.
Somebody got Reeves. You got Reeves proxy, so we close the roll? Oh, okay.
He's got a proxy.
All right, that bill is passed by indefinitely, Senator Pearson.
All right, I'm just told that I've got a couple of bills that have to go to finance, and I'm not intentionally jumping in front of anybody, but I'm going to do it. All 3 of these, Kristen?
The chairman's prerogative. All right, Senator Obenshain, what'd you like to start with first?
Oldie but goodie, Senate Bill 926.
Okay, Senate Bill 926.
This is a bill that we've all looked at before, dealing with contingency fees for outside counsel from the Attorney General's office. It simply caps the amount of the contingency fee and limits it to appropriate cases, preserves more money for teachers and law enforcement and less money to New York and Chicago lawyers.
Senator Obenshain, has this changed in any substantive way
not.
since? Okay, so we're all familiar. There's a
Re-refer,
motion to
it needs to
report,
go to finance.
properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll.
Ayes 10, nays 5.
Okay. What'd you like to take next?
Next is Senate Bill 541. And I'll tell you, I've had a lot of questions about this as to whether this is a message bill or whether it's a bill trying to expand protections for the unborn. It's not. I had a constituent in Warren County where my constituent was in a crash. She was 8 months pregnant, and it was caused by reckless driving, and she survived, baby died. And there was a prosecution. All they could prosecute was for reckless driving, not for the death of the 8-month-old unborn child. And this simply allows the charge to be involuntary manslaughter. We've already crossed that line for homicides, and I would respectfully submit this is a logical extension of that. It doesn't go, or excuse me, this just goes to DUI deaths of the unborn child. It doesn't go to reckless driving, the broad category. So in candor, it wouldn't have affected my constituent. However, that would open up a vast number, and we were looking at the most serious cases. So with that, that's the explanation.
Senator Obenshain, is this going to have a Woodrum impact?
Yes.
Okay.
So if there is a motion, it would have to go to finance.
Wait, Mr. Chairman.
Senator McDougal.
Just so the committee knows, we've carried over every Woodrum impact, including some of mine, and I think Senator Obenshain had some too.
I hope it would go upstairs. Would be my.
Any questions of the patron about?
With the understanding,
any questions of the patron about the policy?
$50,000.
Because it's unknown, so you just put that. But anyway, the Finance Committee can deal with that. You have any witnesses, Senator Obenshain?
No.
Anybody who'd like to speak in opposition? I think you got some opposition. You like to speak in opposition or support? Opposition. Please step up.
Good morning. My name is Gail Dady. I'm an attorney with the ACLU of Virginia, and we oppose this bill. And just wanted to point out that this is a radical deviation from the way that injury to fetuses are treated currently under the criminal code and also under the civil code. Specifically, this bill creates a separate criminal offense for the loss of a pregnancy at any stage of development, including even a fertilized egg, which would lead to major enforcement problems. It also is particularly true in cases in which neither the alleged perpetrator or the woman suffering the injury is even aware of the pregnancy. And of course, while this is a tragic injury to a woman, and we very proudly and strongly support a woman's right to carry a wanted pregnancy to term, and we don't want women to be affected by drunk drivers and to have harm to a pregnancy caused as a result of that. There are very strong protections currently in the Virginia Code to address this situation. For example, there are enhanced penalties for punitive damages in the civil code, and there's also the wrongful death statute, which allows a woman to bring a wrongful death case on behalf of, in response to the injury of having a miscarriage. So we would, again, just ask that this bill be passed by. Thank you.
Thank you. Yes, ma'am. And I just remind you, you've got a minute left, and there are other folks who'd like to speak as well.
Yes. Hi, my name is Galina Varchena, and I'm the policy director for NARA Pro-Choice Virginia, and we oppose this legislation. Like other personhood bills, it treats a fetus on equal footing with a natural person as a separate person from the woman, while overlooking the pregnant woman as a category of victim. The woman is the victim in these cases. Americans United for Life pushes this kind of legislation as a buttress to restrictions of a woman's right to choose and to prosecutions of pregnant women, even when they may not be aware that they're pregnant, for behavior during a pregnancy. As Gail Didi pointed out from the ACLU, the Civil Code shows that there are other less pernicious ways to punish perpetrators for this kind of injury without placing a fetus on the same plane as a natural person and creating two independent sets of rights in the same body, potentially pitting a woman's interest against her fetus. We urge you to oppose this bill.
Thank you.
Hello, my name is Alejandra, and I'm the field coordinator for the Virginia Latina Advocacy Network, and we oppose this bill absolutely. This is another attack on women, and we urge you to vote no.
Thank you. Yes, ma'am, if you'd like to say who you are. And
Jennifer Allen, Planned Parenthood Advocates of Virginia, and we oppose this bill for the reasons stated. Thank you.
Thank you. Senator Obenshain, you want to wind up?
I have nothing other than to say that I didn't introduce this bill on behalf of anybody except for my constituent, and they were heartbroken and devastated as a result of this, and perplexed as to why a more serious charge couldn't be leveled for the death of a full-term baby.
Is there a motion on the bill?
I move to report and re-refer to Finance.
Motion properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll.
Ayes 9, no 6.
Bill reports.
And, Mr. Chairman, last bill I've got is Senate Bill 562. I think Kristen has a substitute.
Senate Bill
I
562.
move the substitute.
Is there a second? Motion properly seconded to adopt the substitute. All in favor, please say aye.
Aye.
Opposed, no. The ayes have it. Substitute is before us.
And, Mr. Chairman, members of the committee, this is a restitution bill. It is a very modest bill. Right now, problem that we're seeking to address is that there are millions of dollars in unclaimed restitution funds out there. Over the past 5 years, $3.5 million of restitution dollars have been forfeited to the Criminal Injury Compensation Fund. Of that, only $200,000 has found its way to the victims of crimes, and we don't have a very effective way of identifying the victims, making sure that this money that's been paid into the courts for the victims, for restitution, actually gets to the intended recipients. And what this does is that it essentially encourages clerks to do a little due diligence before forfeiting those funds.
Okay. Any questions of the patron on this?
And I think this has to go to Finance, too.
I think you're right. Well, anybody in opposition first? Nobody in opposition. Is there a motion? Is there a second? Motion properly seconded to report, re-refer to Senate Finance. Clerk, please open the roll.
Yes.
Creedy, you want to vote?
Ayes 15, no 0.
All right. Sturdivant. Excuse me. Sorry. It's a lot bill. He asked me.
So I had this case.
All right, go right ahead, Senator Serval.
Did you win?
Thank you, Mr. Chairman. Thanks to Senator McDougal, I have the pleasure of serving on the Child Support Guidelines Review Panel in the off-season, carrying two bills that are before you today at the recommendation of the panel. The first bill is Senate Bill 981, And it is a bill that was developed by the Virginia Bar Association's Family Law Coalition at the request of the Child Support Guidelines Review Panel. And it is to deal with calculating child support obligations when you have more complex custody arrangements. This is not an area of law that I practice in, but right now the code only addresses calculating child support obligations for simple sole custody, shared custody, and split custody arrangements. There are some other more complex child custody arrangements that are not covered by the code, and the problem that has resulted is that there is a patchwork of the way that this is dealt with across the Commonwealth in different courts. And so this bill, as put together by a lot of the stakeholders, is to develop one uniform way of doing it.
Is there peace on this bill? Are you aware of anybody who opposes this?
I'm not. My understanding is that there is agreement.
Family Law Coalition supports this? I'm getting a nod that yes, they do. And you're not aware of any opposition?
What my notes say, the National Parents Organization stated it has no position on the bill. Family Law Coalition supports the bill.
Anybody here wish to speak in favor of or in opposition to this bill? Any member of the committee? I'm sorry, yes, sir. You got a problem with this?
Craig Bershman, Deputy Commissioner, the administration supports
Anybody have it, the administration supports it?
Yes.
Okay. Anybody have any questions? All right, there's a motion, a report, properly seconded.
Is there a substitute or anything?
Does it?
Kristen? No substitute or anything?
All right, clerk will open the roll.
Can you vote? Mark, can you vote? Kevin?
All right.
15-0.
Senate Bill 982, Senator Sturtevant moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. All opposed?
Mr. Chairman, members of the committee, Senate Bill 982 is another child support guidelines review panel bill. This one and the substitute that we have just adopted is to conform it to the House language that was adopted.
All right. All in favor of adopting the substitute signify by saying aye. All opposed? All right.
And this just simply says, this bill says that the child support guidelines worksheet that is used to compute the child support obligation for a support order just has to be placed in the court's file, and that a copy of the guidelines will be provided to the parties. And the genesis for this bill, the reason for this bill is that in some cases you had parents, I guess, who did not understand the reasons for their child support obligations, and this would provide them with the guidelines that
You
were.
aware of any opposition to this?
I'm not.
Senator Stewart.
Senator Sturtevant, let me see how I asked this. So the guidelines worksheet, this is something I did many, many years ago, and I don't practice in this area anymore. But the guidelines worksheet has all of the salary data and a bunch of other personal information for both parents. Is that correct?
Don't practice in this area, and so I
So you
don't know the
what's
answer
on
to
the
that.
sheet?
I don't know.
All right, my second question is
Mr. Chairman.
there's been a lot of discussion about FOIA and bills regarding these, and I'm carrying one myself that would address this. Is this going to be subject to FOIA?
A good question. I don't know the answer to that either.
All right, so shouldn't we know the answer to that before we do this? Because if it is subject to FOIA, then everybody now can have these parents' personal information.
Maybe you can phone a friend.
Good morning, Craig Bersham, Deputy Commissioner for the Division of Child Support Enforcement. The main numbers that are on the guideline worksheet are the gross incomes for both parents, and then the child support, any daycare expense, health care expense. Those are the primary numbers.
Insurance information potentially?
Insurance premium information, correct.
Right, so there's personal data of those two parents
Yes.
that could be disclosed pursuant to FOIA, correct?
I don't think that can be, it's not a public record, so I don't believe it can be received under FOIA. The only people that could get it would be data
Mr. Chairman.
subjects.
Senator Stewart.
But isn't that currently the debate between the judiciary and others as to whether or not this would be subject to FOIA? Don't some believe that this information should in these case files, and the judiciary said it shouldn't?
I don't believe that's the case. This is private information. They're not public records.
Senator McDougal? No? All right. Okay, anybody in opposition? All right, bill's before us. You want to make a motion?
Move to report.
Is there a second? All right, it's been moved and seconded. The bill be reported. Does this need to go to finance? All right, be reported. Clerk will open the roll.
Thank you.
All right, next we've got Senator Peake. Save the easy one for last. Can send you out now.
Mr. Chairman, members of the committee, Senate Bill 813. Follow up on my civil asset forfeiture bill. Just planning for the possibility that that bill may not sail through. This is a backup bill which would require the reporting of civil asset forfeitures. And all this does is add one requirement that they already have to report, and they report it to the General Assembly. This adds one requirement, let us know, or two requirements, if the person was charged and if he was convicted. And that's all it adds, and they already do this. There's no financial impact, very simple.
You aware of any
addition.
opposition to this bill?
I'm sure that
You've
the
been
sheriff's
working with the Crime
opposed.
Commission on this bill? Kinda, not really?
I know, it's my own bill.
Okay.
Nobody's contacted
Anybody have any
me.
questions of the patron? All right, you want to move to report?
Yes.
All right, is there a second? All right, clerk will open the roll. All right, that bill reports. All right, Senator McDougal, you've got Code Commission bill.
Unfortunately, Mr. Chairman, I do. It's talks about concurrent jurisdiction and the obsolete provision. Yeah, it's really, it's just like Senator Stanley, obsolete provisions that we can put on the ballot next year. Mr. Chairman, it's dealing with municipal courts and jurisdictions that had limited jurisdiction. I just don't think the situation exists anymore. We did put in, we clarified it to say courts for locality have concurrent jurisdiction with courts of any other locality adjoining such locality over the offenses committed on premises of buildings owned by that locality in another one. So the example would be if the city of Richmond owned a building right across the line in Chesterfield and somebody broke into that building and stole property from the city of Richmond, you could be prosecuted either in Chesterfield or in the city of Richmond because the building was owned by our jurisdiction.
You aware of any opposition to this bill?
I am
Anybody
not.
here any questions? Anybody here wish to speak in favor of
yeah.
or opposition to the bill?
Yeah, Mr. Chairman,
Senator Edwards.
another example is in Salem, which is where Roanoke County Courthouse is.
You like it?
Yes, it's a good
Okay.
bill.
All right, bill's before us. All right, there's motion properly seconded to report the bill. Clerk will open the roll.
That's 14 noes, 1.
Senator Edwards,
Stanley's no. Senator no.
487.
I want to listen to him try to explain that again. I loved every minute.
All right, this is cost of living increase for fraud against taxpayer claims. You want to increase the civil penalties from minimum of $5,500 to maximum of almost $11,000, $10,957, and the cap from $11,000 to $21,916. Correct?
Yeah, Mr. Chairman, this is because of federal law requires it, Section 1909 of the Social Security Act. In order to be in compliance with that, we need to do this according to the Attorney General's office.
Huh?
Mr. Chairman, I wasn't aware of that law. I assumed that because the feds had increased their limits in their Federal False Claims Act, that we were doing the same thing in ours.
So, I mean, it doesn't need to be increased for, I mean, are we going to bring False Claims Act, Fraud Against Taxpayer Act claims under Virginia law for Social Security claims?
No, sir, this is not to address the federal claims. This is a revenue sharing in joint federally state-funded programs, and there's an enhanced recovery. If we do not make this adjustment, the Medicaid portion of a KTAM would be reduced by 10%, and it would be equitably shared 50-50 instead of 60-40 in the favor of the Commonwealth. This just maintains current law by tracking the federal adjustments.
Have we been out of compliance?
Yes, sir.
Have we been sacrificing our 10%?
No, sir. We were.
So have we gotten notification that they're going to start?
Yes, yes, Mr. Chairman. We received notification from HHS OIG that we would lose the reduction beginning in December of 2018.
All right. Anybody have any other questions?
Mr. Chairman.
Senator McDougall.
Maybe all of these, including all of the asset forfeiture amounts, need to go through the legislature so we can keep a closer tabs on this and should be approved specifically in each budget. So with that, I'll move to report and re-refer to finance.
All right, it's been moved and seconded to report and re-refer to Committee on Finance. Clerk will open the roll. All right, Senator Edwards, you have one more?
I do. This says
791.
791. You all, I'm sure, remember in the September of 2015, an employee of Channel 7 shot and killed Allison Parker, a reporter, right before 8 a.m. on live television, and Adam Ward, who's the photographer or the cameraman, and also seriously wounded the chairman of the Chamber of Commerce down at Smith Mountain Lake, who was being interviewed. All this was on live television. What this would do, it turns out this gentleman who worked for Channel 7 had a bad record of violence and other activities with other employers that Channel 7 knew nothing about. And this would simply mean that if an employer receives this information, they can take action against somebody like this, and also can reveal this to future employers, potential employers, about the behavior and the record of the person involved. And this would give some immunity to the employers who both take action and also provide information to other potential future employers. As I mentioned, Channel 7 knew nothing about this guy's background, and they never would have hired him had they known about this. And they did fire him, and he came back, unfortunately, 6 months later and committed two murders on live television. And I'm sure you all know all about this. It's heavily publicized. So that's what this does. And it does provide immunity. It does provide attorney's fees in the event the employer or potential employer who
John,
is sued.
Does this, I mean, doesn't this create a duty on part of employers?
No, it just means that employer is to encourage people to share this information.
Well, what if they
It
don't?
doesn't make them do it.
What if they don't? What if is there a cause of action against them for not?
I don't think there's a cause of action here.
You don't think they'd be liable if something bad happened and they didn't? If they used...
It just gives them the right to do it. It doesn't make them share the information the way it's written, the way I understand it.
But aren't they, I mean, we looked earlier at the provision in 801 dealing with immunity. They've got immunity under current law, so if they've got any concern, they have immunity for passing that along, don't they?
Well, it says any employer who makes a voluntary report. I don't think you could say they have a duty to do it.
No, I know, but they already have statutory immunity for, I mean, don't they have statutory immunity for passing along information to a potential subsequent employer?
Reference reports are voluntary, and a lot of employers don't do reference reports for fear of being sued. And this
Right.
is like a reference report, but specifically, it's not like any reference report, specifically about an employee who has this kind of a record. And so it immunizes the employer from passing this information on to another employer or to law enforcement officers.
Mr. Chairman.
That's
Sarah
all. There's
McDougal.
no duty
Right.
to, yeah.
Maybe this is for Charles or Mr. Steve. If there's already immunity for employer, what additional protection for an employer would this bill provide?
It's not,
Well, let's ask
well,
counsel.
it makes it clear the specific immunity in this particular situation. I don't think there's already immunity. What it is if you pass along information that's false and misleading, it's like defamation. Whereas here, though, it gives a specific immunity. And
Mr. Chairman.
Senator McDougal.
Senator Edwards and I clearly have different thoughts on what that means. If we put something specific, then that means general is trumped, and maybe that general immunity doesn't exist. So right now, I think that general immunity does exist. So where am I missing that general immunity not existing if you're telling the truth?
Well, this makes it a little stronger. It says the presumption of good faith by the employer can only be rebutted upon clear and convincing evidence that the employer knew such report was false. In other words, it heightens the burden on the part of the person suing the employer to show it was false and defamatory. So it does make it, and if this is really, if an employee doesn't like it, it's a higher standard to sue the employer. So it
Mr.
does
Chairman?
change it somewhat.
Senator McDougal.
Is that not similar or exactly the same language in the current statute? Maybe Kristen could help us.
Mr. Chairman, the current statute is 8.01-46.1. The difference between Senator Edwards' bill and this statute is that in the current immunity provision, it has to be upon request. But the same language with the heightened presumption and the clear and convincing evidence standard is in 8.01-46.1.
This would also add attorney's fees. If the employer wins the case, the employer get attorney's fees from the employee who's claiming to be defamed.
How about an employee, and I mean, I understand what you're trying to do. How about an employee who makes a defamation claim against an employer who maliciously made that report? I mean, they're not going to get attorney's fees, are they?
No, you're right. It's a one-way street on attorney's fees. This only applies to the employer who wins the suit is entitled to attorney's fees.
Mr. Chairman?
The way it's written.
Senator McDougal.
I don't want to do the bill harm, but I'm not seeing where it adds anything to the law that's not already there today. So I would move that we carry it over for the year, see if we find that there's something different than what's in the law today, then we can revisit it. But it seems like we already done this.
All right, anybody in the audience wish to speak in favor of or in opposition to the bill? All right, Senator McDougal's made a motion to carry the bill over for the year. Is there a second? All right, it's been moved and seconded. Clerk will open the roll. All right.
Ayes 10, nays 5.
All right, with that, we have, with the exception of the one bill from Senator Chafin, which is undergoing reconstructive surgery, we have completed the committee's docket with respect to this committee's bills. Unless anything else is re-referred to us, we're done, and we'll start taking up House bills. So I thank the committee for your hard work. I apologize for the length of this meeting, but we're done. Committee will rise. Good job.